How's everyone doing? I'm about to go live on YouTube, which I am live now. Peace to the guys. What's up? And I'm live right now, so I'm also doing a call in. So if you want to talk to me, go to my TikTok. It is at Yusuf underscore EL underscore 19. That's the only TikTok I got. It's a whole bunch of people who have made clone TikToks of me, so you're going to see a lot. But my TikTok is Yusuf, is @ Yusuf underscore EL underscore 19. You come over there if you want to talk to me, you can talk to me. Today I want to talk about this word person. Because I think that it is a word that has to be discussed because it is a very big contributing factor to a lot of confusion and why people reach certain legal conclusions the way that they do is because of the way that a lot of us, when we first are brought into this space, the way that we are introduced to the word person. Because we all come into this space through some sort of trauma. Either, you got you got some sort of family court issue, you got some kind of criminal case, maybe a foreclosure or something like that, or, a divorce proceeding, custody battle. It's going to be something like that you're going to come through the door on. It's going to be some sort of issue that you're going to be contending with. And then you're going to get introduced to people who, initially when you first come into this space, you're introduced to people who know about the information, but they don't really understand it all the way. That's how it was with me. The dude who introduced it to me, he knew about it, but he didn't know it himself, And so, like during our time, what was really big was the gold fringes on the flag. Everybody was coming in talking about the gold fringe on the flag was indicating that it was an admiralty jurisdiction, but that's what was prominent in front of everybody's mind, and what they were going into court challenging the court on was the flag they had in there, and then the "I'm not that person" arguments, those started to crop up a lot too. That I'm not that person. So you come into the door and you're taught about a straw man, the straw man, the all caps name, which it is a legal identifier. I think the issue or the problem we're having is, number one, we are not taught when we come through the door to clearly understand the difference between public and private and how each of those domains operate. Once you understand that, now you begin to understand the mechanisms the public utilizes to classify certain violations of statutory violations in the public that happen in the public. See, the public is a land of legal fictions. It is a land of fictitious entities. And that is why they put everything in capital letters. And a fiction is just a construct of the mind. The state of Georgia or the state of Texas doesn't really exist. There are not any real boundaries, that separate each of the individual states. These are all fictions. These are all constructs of the mind. However, fictions are necessary, especially when you are doing, like for business purposes, and especially when people wish to aggregate capital and invest in things as a group. There's a purpose for legal fictions and where they fit in. However, I think the problem is when we get into this "I'm not these person" discussions, I'm a real living soul and all of this right here, they understand that you're a real living soul. It's the conduct that you engaged in that created the persona that determines what capacity that you have to act in, and then it gets classified in order to determine rights, duties, and liabilities. They got a whole framework set up in the public, and no one's ever told any of us this, of how this thing is really set up. From what I can determine, the only avenue is if you wanted to attack it is to attack it commercially, because it is there is some sort of commercial basis for everything that they are doing. I know people are going to think, yeah, of course you would say that, but I'm just being honest because what really kicked off all of this was House Joint Resolution 192 of June 5th, 1933, Public Law 73-10. A lot of you don't talk about that anymore. You don't understand what was the catalyst for all of this, but that was the catalyst for all of this when they removed the gold out of circulation. Okay, this is what created this welfare state and this dependency on government, which has helped government grow to such gargantuan proportions because we have been depending on government. When a constitutional republic, people don't depend on government. Government, their only duty to you in a republic is to protect your borders, protect your property, and protect your liberty. Once again, this is how Donald Trump was able to, in his State of the Union speech, how he kind of set up the Democrats by saying, is it not the duty of government to protect the borders and protect the people's liberty over that of illegal aliens? And they didn't stand up. All right, well, that's their duty. That's a duty that they have, a duty. And duty is something that is very, very important for people to understand. The only duty that government has to you is to protect your borders, protect your property, and protect your liberty. Anything outside of that is a benefit and a privilege, which at the aborting of this country, very few citizens engaged in. Very few people. I think that was even a foreign concept in the early ages of America to depend on government. There wasn't anything like welfare, anything like that. And, people grew their own food. They educated their own children. They built their own houses. Everybody did everything for themselves. And that was the spirit of which the United States of America, in its guaranteed Republican form of government, that's how it operates. That is the private side that you're speaking of. The public side, this is where people get a little confused too, because they think they can declare privacy and then take that declaration wherever they go into any space that they want and feel like they have some sort of immunity because they made a declaration of privacy. And that's not how public and private operates. Privacy is a space, operates within a certain space. You have to locate where that space is and stay within it. If you venture outside of it, you have ventured outside into the public. Public rights begin where private rights begin where public regulation ends. Private rights begin where public regulation ends. That's the demarcation line that you have to ride. So once you understand where the demarcation line is, now you can begin to structure yourself in such a way and take into account where the demarcation line is. This is why it takes a skill to be private. It's not something you declare. It is something you have to set up and something you have to operate within. Okay, it's not a declaration. You can declare all you want to, but declaring something does in no way change your status materially because everything in law operates off of actions speak louder than words. And you can Google this, Chat GPT this, or do whatever you want, what I just said. Actions speak. Ask Chat GPT to give you all the case law regarding actions speak louder than words. He said, I want a U.S. citizen and they kicked me out of the jury. Yeah, a U.S. citizen, let me tell you something. A U.S. citizen is an individual that is an acceptor of benefits and privileges because a U.S. citizen is attached to that social security number. That social security number. So that's why one of the first things you have to do in order to be considered operating in a private capacity is stop using the social security number and start operating through entities that interface with the public properly. That's one of the first things you got to learn how to do. Take everything out of your name. See, the wealthy understand own nothing, control everything. As we still haven't gotten the message. Even though a lot of you hear that phrase, you really don't understand that is the way. That is the avenue. That is the door. There is no other. That is how you have to operate. You have to own nothing, control everything, if you want to have this status that you're talking about. Let's see, it says, but no right can be taken away for a privilege. See, and this is something else that gets regurgitated a lot, and I'm glad this individual did bring this up. Let me read this to you. It says, but no right can be taken away for a privilege. The government is claiming to have dominion over the property and the people. That is not a designation. Now, this right here is strictly echo chamber rhetoric that in no shape, form, or fashion can she substantiate what she just said in any capacity. It is something that all of us hear when we first come into this space. I've been hearing people say that for 20 years, the last 20 years. So right there, that lets me know is that she is not an individual that does independent investigation. She is just simply regurgitating what somebody else passed along to her, and she felt like it sounded like it was something good. Now, let me allow you to educate you properly, okay? The government is not converting rights into privileges. You are thinking privileges are rights. That's what it is. You're the one that has got it backwards. You're trying to convert a privilege into a right. That's what it is. And most of this is surrounding that right to travel, which you don't understand. You don't even understand that. That is so ridiculous. I hope that's not what you're referencing, because that is so ridiculous right there. You know, it just indicates, listen, let me tell you something. There's a lot of, you're going to have to accept this. There's a lot of incompetency in this space. And a lot of incompetency got passed down in this space as well. A huge amount. A huge amount. I was susceptible to it too, because I came into this just like all of you. You know, I had to, I got the same education that you got, you know, that, oh, they stealing our rights and they can't convert a right into a privilege. You know how many times I've seen that shit? You know, I done seen that a million times. I've been in this space 20 years. Do you really think that you can come into my chat and post some sort of slogan that I haven't heard already a million times? Really? That's what's insulting, to really think that you know something that I don't. You don't know nothing I don't know. But the extinguishment of the right of vehicular travel, they didn't extinguish the right. Rights can be regulated. You won't Google that, will you? When I say rights can be regulated. You won't Google that, because you don't want to know what the real law is. Because see, what you're talking about is some made up shit. Rights can be regulated. 100 years of case law about on automobiles says so. There is no case law anywhere in existence that says that you have a right to operate a motor vehicle, conveyance, however you want to say it, without regulation, because that falls under the public rights doctrine as well as public safety doctrine, which police powers falls under, which does not have to be enumerated under the Constitution because it is an implied power. Now, I know you're not going to research any of the things that I just said, because if you did, you would see that I'm right. But you don't have any interest in studying law. You have an interest in regurgitating things that you heard in echo chambers. And I'm not impressed. Not at all. She doesn't understand how the law is necessary. These people think they have the right to do whatever they want to do. That's the key issue. The key issue is you're dealing with a mindset of people that think they have a right to do whatever they want to do, public or private. That's what they think. And really and truly, I think there's some sort of anarchist or some sort of Marxist type of, they've been infiltration that has occurred. It really is. I'm trying to tell y'all. I've been doing this a long time. They always want to keep you in an angry state, angry at the government. And you know, that's why the government has labeled you as terrorist. They've labeled you as terrorist, and they are well within their right to do that, because when you really understand how the law operates, you can see that you are operating from an ignorant position. And then what you're trying to do is you're trying to assert a private right in a public regulatory space, and then say that it's a right, but it's not. It's not a right. Travel, the right to travel, anybody can look it up. The right to travel means the right to egress from state to state. America was set up like Europe. The people who set up America are the same people who came from Europe. When you go into Europe, you say that Europe is set up just like America, only you have Germany, you have the Netherlands, you have Belgium, you have Switzerland, you have France, Spain, Italy, Greece, Portugal, the UK. All of those, they're states. Like over here, we would call them states, but they're countries over there because that's what a state is. It's really a country. That's why in our country, each of our individual states has their own constitution because a state is a country, like the state of Israel, okay? So that's a country. However, what we decided to do, unlike anybody else on the planet, we decided to unite all the states together, okay? And so we had a right, you have a right to travel, which means you have a right to go anywhere you want in this continent or in the North America without a passport. However, in Europe, you have to use a passport. I can't go, France and Spain right next door to each other like Georgia and Florida, but I can't go from Spain to France without a passport. That's like requiring a passport to leave from Florida to Georgia. Here we have a right to travel. That's what the word means. It's not discussing the mode of travel. Now, they explain this to you a million times in all of the case law that you cite, but you don't read it. All right, but you'll come in here in my chat and start trying to educate me on something, and you are illiterate. That's what you are. See, like this, I have a right to vehicular travel. It don't say that anywhere. She can't show you one case law that says that, and if she pulls up the case law, I'm going to read it and show you how illiterate she is. Pull up the case law that substantiates what you just said. She ain't going to do it. They ain't going to do it because you know what they operate off of? They operate off of you believing them. They operate off you believing them. They come with a lot of emotion and they expect you to believe them. Or they'll offer some bullshit type of evidence that understanding that you yourself don't have a lot of knowledge about this. See, they can't get over on me with that bullshit because I'll read the case on their ass. I'll read the case. I'll say, okay, where does it say this in this case? They can't throw that citation of authority in front of me and expect that just to fly. I'm going to pull it up and read, and I'm going to read it in front of everybody. Aside from being a state citizen, is there a state of the people? I have not found. No, it's just state citizen. Listen, man, you're a citizen of the state. The law recognizes state citizen versus U.S. citizen. The law recognizes those statuses. Okay? It recognizes that. That is real. And that is something that you are striving to get a hold of. Because the U.S. citizenship is a federal citizenship. And it's a federal citizenship by way of you accepting benefits and privileges. But see, here's what the federal government does. The federal regulatory space allows you to select what type of entity you want to interface with it with. That's why the IRS issues you these different persons. One of the persons is called an individual. Another person is called an association. Another person is called a partnership. Another person is called an estate. Another one is a company, a corporation, and a trust. So they give you, it's just like playing the game of Monopoly. When you first begin the game, you need a token to play the game. They just give you a default token. The people who refuse to educate themselves, like this lady in my chat right now, who does not want to educate themselves in commerce, and they're not competent enough to conduct their own commercial affairs because they won't look up the definition of words, understand principles of law, understand in their mind the distinction between public and private, and acknowledge that the government does have authority in a public regulatory space. They prefer to be anarchists and people that are emotionally charged and then just relax in their ignorance. Just ignorant. And she keep on commenting, and every comment you made only demonstrates further that you don't understand nothing about law. Nothing. You're just reading stuff and posting it. You don't even understand what you're reading. You don't even understand what you're reading. So a state citizen, while not being a federal citizen, may be considered a foreign person in relation to the District of Columbia. No, What you're going off of is decorations. What classifies you is your conduct. You need to get that through your head. All right, y'all stop looking for some kind of way to declare your way out of some shit. All right, because see, conduct requires you to have some sort of accountability and responsibility, which is what I see a lot of people in this space, what they avoid, which is another reason why I believe that it's been infiltrated by like some sort of Marxist, socialist, communist mentality. There's a lot of people in this space that think they have an entitlement right to something. And that right there is straight up socialism, Marxist mentality. That is not anything that a patriot would be thinking like. But a lot of these people, they think like that. I'm trying to tell you, bro, I've been doing this 20 years. They keep you and you can fall into it. You know, you got to be a strong-minded individual not to fall in that trap of the emotionally charged rhetoric that gets spewed in echo chambers. You're dealing with law. And let me tell you, in law, the law is about precision. It was like when I was watching a movie of this husband and wife. The husband was a doctor and the wife was an attorney. And he was kind of like, flexing on her, talking about how his profession required more precision than hers. And she fired back and said, my profession requires just as much precision as yours. And let me tell y'all something. It absolutely does. Last night, we went over a case about a trust protector. And let me tell you something. These attorneys did steal about $1 million from this man. This man had an accident and became a quadriplegic, okay? So he hired an attorney and won a big settlement. The settlement was for about, I don't know, he had about $1 million in the settlement, 1.2, something like that. They put the money in trust, in an irrevocable trust, and appointed, had some trustees appointed, and the attorney who actually helped him win the case, he got appointed as the trust protector. But here's the thing. The attorney is the one who prepared the indenture agreement, and he's also the one that wrote the powers of the trust protector, which only was basically to replace, resign, and he only had a few powers that he had, which limited his liability. See, when you're in a trust framework, you have what's called fiduciary duties. The punctilious of an animo sincere. It's called the punctilious of an animo sincere. All right, so you have a fiduciary duty that you have to conduct. All right, but the contract is what controls. The rules of equity is what guides, and the contract is the law and the trust of a case. So he wrote the law up for it. So he wrote the law up. So then shortly after those, the trust got established, the other trustees resigned and the attorneys replaced them with trustees from a homeboy who had his own law firm. And then they began pillaging the trust. When they went to court, they weren't able to produce evidence to show an injury. First of all, they didn't appear in their personal capacity. They only appeared in the capacity of the trust. So they pled damages individually, but didn't make an appearance in the caption of the pleading that way. All right. So the trust itself, so they dismissed all of that, and then they didn't have any evidence of damages. They should have conducted an accounting of the trust by a CPA and then brought that into court. But there wasn't any of that done. They were just using an emotional argument that this is not right, like these people do in the chat. And you can't do that in law. Let me tell you, this space right here has no place for emotion. There's no place for emotion in this space. None. This is straight science. This is straight cause and effect. This is straight, you either know or you don't know. There is no in between. So, this space ain't for you. If you're not riding, if you don't have that etched in your mind and you understand that this space is not for you. And here's the next thing that I need to tell you. You got to understand also that the words you use in law have a very different meaning in everyday parlance. And you have to learn principles of law. But see, these people, they don't know any of that. They don't know the simple principle of public versus private, because they keep talking about they taking some rights from us, or they're converting a right into a privilege. When it's the other way around. You're attempting to convert a privilege into a right. That's what's really happening. And you don't understand that because you don't understand law. You don't understand law. I'm telling you, you don't. I'm telling you, I can say this with my chest out because I read it every day. I read it there. I don't do anything but read case law. That's all I do. And it's all consistent. It doesn't contradict itself anywhere. It's all uniform and consistent. And it ain't saying none of the shit that y'all say in those echo chambers. And please don't come in here and start trying to teach me about private trust. Oh my God. Please don't do that. Please don't do that. Please don't even do that. See right here, the living man has unlimited commercial capacity. In legal spaces, you must know your legal fiction capacity. Will wear a mask whether you know it or not. Well, see, you talking about unlimited commercial capacity. Capacity gets classified into rights and liabilities, which the capacity they're talking about is going to be something contractual. Because if you're operating on the private side, you're operating through contracts. Rights are enforced through contracts. That's how private people enforce their rights, through contracts. We enforce our rights through contracts. All right? You got to understand contracts, and you have to understand how to hold property, and you have to understand how to interface with the public. So you need to, one thing is mandatory for you to learn is private trust. That's not an option. That's not an option to learn private trust. You have to learn private trust if you're going to operate in a private space. You have to. That's not an option. You can't be calling yourself private and you don't know how to operate through one. I'm just keeping it real. You can't call yourself private and you don't know how to operate through one. Hold on, let me see who this is. Let me let 9 the speaker in. What's going on, brother?
Peace, God, peace.
How you doing?
Man, I'm good. I actually was on a mission. I did an interview yesterday. I had to kind of get some things corrected with some people in the audience, kind of concerning some of the same information about what you mentioned about rights and privileges. People are definitely confused about a right and a privilege. And they think, we all heard that Murdoch versus Pennsylvania case. We know that's where that comes from. Right, you can't convert a right to and then license it, attach a fee, then try to convert it into some privilege. That's in that Murdoch versus Pennsylvania,
right.
But the thing is, what they're talking about is, though your rights are not limited to the Bill of Rights, there are things that the government does grant and say, hey, we're going to make sure y'all have a right to do X, Y, Z, but they would in fact be conditional. So there are things that are God-given, but voting is not a God-given right. Therefore, they can apply some regulation to it in the event that you become some felon or what have you. Right? These are things that are not necessarily God-given. You have a right to travel. You don't have a right to run an automobile however you want to run an automobile. That's something that can be regulated. That is something that can be restricted.
You know, I'll ask them this question. Do you have a right to travel through a school zone at 100 miles an hour? Do you have a right to do that? Since they don't have since you can just operate, do you have a right to operate a motor vehicle inebriated? Can I get drunk?
Here's the thing.
And you telling me you don't have any regulatory authority over me. That's what you're saying. All right. So you basically what you're saying is I can drive this 6,000-pound piece of metal inebriated with the possibility of killing someone. Let's say I didn't. See, public safety is about prevention. It's not about after the fact. See, that's why they try to bring this common law stuff into this space too, that I have to injure someone. Well, that's in the republic. That's in the common law, okay? That's not in this space. You're in the public. That's only in the private that you have to have an injured party, okay? In the public, they don't have to have a physical injured party, a real living soul. Private is when two people are interacting with each other. That's called a tort. Okay, but when you come into the public, no, the public is the land of artificial persons and things of that nature, but they use persons to classify your conduct that you engage in a public regulatory space. That determines your capacity, that gets classified, that determines rights, liabilities, and duties.
Here's what I've failed to understand, that people don't understand while we're talking about the rights of men. Here's the thing. If I'm a man in a community, amongst other men in the community, do we then have the right to elect representative officials to go and legislate on our behalf to make sure you can't drive no 2-ton vehicle 100 miles an hour when my children go to school? Do I have a right to do that? it's very interesting that we would disregard that right and say, I got a right to move my car how I want to move my car. Well, I got a right to make sure that we do what we need to legislatively to make sure my kids are safe when they go to school so that you can't do no shit like that. I don't know why that's disregarded.
You know, see, the problem is the problem is, man, when how we're taught about this word person. Well, first of all, nobody is being given a clear map of the landscape of public and private. They'll talk about the Constitution, but the Constitution is in the public. It's public law, okay? Constitutional law, criminal law, administrative law, tax law, public international law, all that is in the public side. The public is the domain of government and public servants. Our domain is in the domain of property, contract, tort, family law, private international law, property law, contract law. That's our side that we're operating from. Okay, so the Constitution has clauses in there to guard that domain, and then the Supreme Court justices, who are the defenders of private rights, because that's what they do, they put a restraint on government, because that's what the Constitution is. The Constitution is a document that forms government and restrains government. All right? When you're talking about God-given rights, the Constitution doesn't afford you rights. That's why on the private side you can exercise your rights, but it has to be outside the purview of the government. That's when you can do it. And they got a space for you, reserved for you for that purpose, and that's what private ordering is. That's where you're supposed to be operating. You can never engage in anything that has the possibility of injuring another person and be outside 100% outside their jurisdiction. Let me tell you something else. It's impossible to get 100% outside their jurisdiction, period, because you're living here in America. That's why people leave the country, okay, and go to other countries, you know what I'm saying? That's the only way you can be 100% outside of their jurisdiction. But if you want to limit their jurisdiction, the first thing you have to do is you have to stop participating in public regulatory spaces. And you have to identify what those are and structure yourself. And if you do need to interact with them, you need to interact with them through some sort of other artificial entity like a trust, a C Corp, S Corp, LLC, or something like that. But that requires some effort on your part. I understand. It requires you to develop a little business acumen about yourself. It requires you to take some accountability for your actions. But this space is not for people. Sovereignty is not for people who don't want accountability and who refuse to educate themselves and grow. Those who hope to be both ignorant and free open for something that never has been and never will be. That's what Thomas Jefferson said. So if you're still sitting here regurgitating information that has been regurgitated for the last 30 years, I've been here 20 years, and you coming into my chat room saying the same thing, almost word for word, that I heard for the last 20 years, and got your chest out thinking you really saying something to me for real?
Yeah, people they're not stupid, they're not scholarly, and we romanticize certain informations. Like, for example, and it's very controversial. I'm currently erecting my own channel, kind of doing some debunking myself with this injured party disposition coming from the case with the corpus delicti. I talk about corpus delicti. It does not mean what people have tried to take and run with it. Corpus delicti meant the body of the crime. You can see where somebody read that and thought that what it was actually referring to was saying an actual human body that some crime had been imposed on. But no, it's talking about the compulsory, the evidence. It's even in the case, the objective evidence that shows and demonstrates the body of a crime so that someone can then be charged with the crime. That's what that's referring to.
Yeah, corpus.
You will not see in any case.
That means
you won't see it. Yeah, Scherer versus Cullen. Yep, Scherer versus Cullen. You will not see in any case where it says, in order for there to be a crime, there must be an injured party. You will only see someone quote that trying to misappropriate Scherer versus Cullen, but it doesn't say that in the actual Cullen case. It says corpus delicti. It mentions what it means. And if you would just read just one paragraph down, that's it. Just one paragraph down, not even too much. It'll clearly tell you it's talking about the objective evidence needed to be accumulated so that someone can actually be charged with a crime. Sufficient evidence to charge somebody with a crime. That's what that's referring to.
Another thing they misquote is Hale versus Hinkle. I'll watch them quoted on the internet, and they'll leave off a part of the citation where it says he owes no duty to the government as long as he does not violate their rights. All right, so they leave the part off where it says as long as he does not violate their rights. See, there's something called the public rights doctrine. Okay, so the way the phrase really went was you can do anything you want as long as you don't infringe on the rights of others. And what they refuse to acknowledge is that the public has rights too. So you can do whatever you want as long as you don't infringe on the rights of others. They changed that to as long as I haven't injured someone. I do it, and that's not what it is. It's infringing on the rights of others. And the public has rights because they received the delegation of authority from the Constitution. Okay, so that is their space that the statutes represent the delegation of authority from the Constitution. And if it is unconstitutional, the Supreme Court justices will tell you that. This is another reason why you read case law, because the justices will tell you where the demarcation line is. They tell you where the limits of governments are all the time. That's how you find out where the private is and where the public is. The government will tell you all the time, especially Supreme Court cases. That's what unconstitutional is. Unconstitutional means that the government has encroached into the private, outside the ambit of their delegated authority. That's what it is. But you gotta respect their domain just like they have to respect yours. So you think it just goes one way. It goes both ways. You have to respect their domain and they have to respect yours. And that's what you have to understand. And that's what's hard to get people to understand. I don't understand why, because it's easy to see when you read. When I read, everything I read is saying that. Everything. Not just some things, everything. Everything I read. So I can only conclude that almost none of you are reading any. I see where individuals will say things like, case law is not real law. They'll say dumb shit like that.
That is, I have actually been hearing that lately too, and that is some of the weirdest shit in the world.
You know what? Those are the individuals. You know why those individuals say that? Because they see stuff slipping out of their hand. They see that we are attempting to force everyone into a space where it's going to require you to raise your level of excellence, and they don't want to do
That's
that
true.
because they're not real scholars. They don't like
That's
to
true.
read.
This the thing. Case law. We do this primary, secondary, tertiary, right? This thing with case law, but the thing is, in some cases, most cases, case law is very much so primary. Some cases, it can be secondary. In some cases, it can be tertiary, such as when you're using a particular case that simply cites something from a legal encyclopedia and not actually applying law or something to a certain set of facts. You could use it if that way, if you like to do it, and that way it will be secondary. And in the latter, it will be tertiary. But that doesn't mean it's not primary or that it's not real law. It's not legislation, if you want to say that. It's not bicamerally legislated.
But it's called judge-made law. Let me tell you something. Another name for case law is common law and judge-made law, because the judges interpret the law. The legislature, they create the statutes, but the judges are the one that determine how the statutes are applied. Okay? So that is what their job is. And let me tell you this. It is primary in equity. Because in equity, it is the principles that govern and direct everything in equity, or the principles of law. So that is why, like, if you want to learn trust, the number one way to learn it is to read case law. Because you see all the various, when you read, that's why if you get any book on trust, Bogart's on trust, Perry's on trust, American jurisprudence on trust, restatement of the law on trust, you get any of those, they all refer you to case law.
Because it is law. It's just not legislation, and that's okay. It's still law.
It is see, that's what common law is. See, let me explain common law. Common law means unwritten law. It's the lex non scripta. All right, it's not written, okay, but it's a body of customs and principles of a people that have lived together and shared together that came into law. This is the way we live together. This is the law of our community. All right. So those customs and habits, when there was a dispute, when it got taken before a judge, the judge would use those principles that had developed to make the decision on facts that had appeared before the case, and then write his opinion. The opinion is not the law, but is the evidence of the law, because the common law is not written down. But the written opinion shows how the common law was applied to a set of facts that appeared. That is why if you have a case you should go to the law library and see if you can find a case that is similar to yours, because this is why it's called controlling authority, because the judges have to stay consistent in their decisions. So this is why they're always referencing citations of authority to support their opinions, to demonstrate that they are remaining consistent, okay, that they're all ruling the same way on a particular point. That's what case law does. This is how you control the judge also. When you come in with controlling authority and you introduce it into the evidence file, okay, the judge has no choice but to rule that way. Because if you take him to the appeals court, he's going to get overturned. Why would he go against you? And you just introduce controlling authorities that match your particular situation. You're crazy. What he's saying, that's why you see it in everything. They're constantly using citations of authority, because that is to demonstrate that they're remaining consistent. We consistently have decided that this is a consistent opinions throughout all jurisdictions, or at least within their local jurisdiction. Because if you want to use case law, you use the case law from your jurisdiction, not from anywhere else. You know, you don't use Oklahoma case law in the state of Texas. You don't use that. Now, federal law applies. You have something called federal common law. Why it's called federal common law? Because that's the body of federal decisions that apply in a federal jurisdiction when there's a federal question.
Can I speak on that just a second? There's a guy that's big into this. He's known as like the equity guru, and I'll be honest with you, he sucked trash, absolute trash. But he halfway read a case, put a citation on the screen. It doesn't even say what he said. It says on the screen. But there's this disposition now that he's made popular that there's no federal common law. That's not what the hell that case said at all. It's what is it? Erie Railroad case.
Railroad decision.
Thompson's Railroad case. Yeah.
I don't know why.
What it says is there's no. He said, well, he was trying to make a point to say that there's no more common law, which is stupid as hell. It says that there's no general common law. What it's referring to is no general federal common law. What it's saying and why it's saying that is, hey, the federal cases that have been adjudicated as far as erecting some common law may not apply generally to every state in their situation. That's what the fuck they're saying.
It doesn't. And see, it has to be a federal question. Federal common law, all it means is it's the body of case law. That's all common law. I mean, anybody can Google this. This is what amazes me. Why you don't Google this? Why don't you Google judge-made law? Common law means judge-made law, and see what pops up right now on Google. Why all y'all don't do that?
Well, this the thing. They will do it, and they'll read that. But see, here's the thing that I'm noticing. They'll do it, but they don't know what it means when they do it. Like, they'll do it. We've been hearing this for a minute. They'll do it, and they'll know that, but they don't understand, comprehend it, or know how to apply.
Explain it. When you say judge-made law, what they're talking about is the legislature makes the laws, the executive enforces the laws, and the judiciary interprets the laws. That means when the legislature creates a statute or whatever, okay, the judges interpret the statute. That's why when you go to the law library and you pull the United States Code off the shelf, or United States Code annotated, or United States Code services, you go to the statute, underneath there, you're going to see all this case law. That case law is to show you how that statute was applied in different situations. And that's what you're looking for when you go to the law library, when you're doing research on your case to determine whether or not you're going to find some controlling authority. What you're looking for is something to control the judge, to force the judge to rule a particular way. That's why people use case law. And they're looking for controlling authorities, and you're looking for controlling authorities, because it's stare decisis, to stand by things decided. To stand by things, that's what that means. They have to stay consistent in their rulings. So only a fool would say that case law doesn't mean anything, and only somebody who doesn't understand what the word common law means would say there is no federal common law, when federal common law is right there in Black's Law Dictionary.
See, it's the thing. He was reading too damn fast, trying to make a point that didn't need to be made. The word general was there, and he didn't read the damn case. The reason they said it is because someone tried to apply a federal common law decision to a state case, and they were saying, hey, that is not how that works. There's no general federal common law. That's the only point that was being made, clear as day.
That's right. There's no general federal. The federal common law applies only to federal questions, federal question jurisdiction. You know what I'm saying? So you
He
cannot,
didn't read
you
the
can't
case.
make it apply to everything.
Yeah.
They got,
He just didn't read the case.
well,
He didn't read
it
the
ain't
case. He
even
wanted to
just
make
that.
a point about equity.
It's not even just that. It's a lot of people who really don't understand law who are teaching, and they shouldn't even be
This
in
is
that
true.
position. They shouldn't even be in that
This
position.
is the truth
They shouldn't
at
be in that
all.
position. I'm trying to tell you. I've been doing this 20 years,
On the
man.
same
I'm
page.
still learning stuff. I'm still learning stuff, I've been doing this 20 years. I've been reading every day. I've been on the internet almost every day. I got a content that go back 20, 15, at least 15 years. I've been doing this a lot. I've interviewed a lot of very popular gurus. You know what I'm saying? I've been in debates. I've been to private seminars, all kind of stuff that I've seen during my time in doing this, and I'm still learning things. And I'm gonna tell you where when really things start to really progress for me is when first and foremost is when I really developed the habit of researching things for myself. And that may be a little bit to my arrogance because you could be listening to someone who's not as intelligent as you are. You're listening to this person, he's sounding good, but he don't understand basic grammar. He don't know principles of law. He doesn't understand that legal terms have a different meaning than they do in everyday parlance. It's a lot of little things like that. And because you don't know, you'll be listening to this and you'll read something on its face like this lady was doing just in my chat. She reads things on their face and think it has a particular kind of meaning. But as soon as I see it, I know it doesn't mean what she thinks it means because there's certain principles she hasn't mastered. One of them is public and private. That's the main thing. That's like the number one thing. I'm trying to tell you. And also not understanding the Constitution, like not understanding separation of powers. That's a big one. People don't understand constitutional principles. They don't understand delegation of powers doctrine. They don't understand plenary power doctrine. They don't understand, it's just things like that. You got to everything is sectioned in the law and is structured. The first thing you got to do is see and learn the structure. Once you see and learn the structure, now your thoughts are organized in how to think. Like as soon as somebody says something to me about child support, my mind switch over to private law. It's going to private law mode. Just as soon as I hear the word child support, as soon as I hear the word taxes, it switched straight into the public law mode. Government authority, just automatically, as soon as I hear the word. Criminal law, automatically I switch to public. And in my mind, I'm seeing that line where somebody crossed that line. Like this is why they got to get a warrant before they arrest you because they need to verify, they need to attest under penalty of perjury that you indeed did something that violated something in the public. And then they can leave the public and come and get you in the private and bring you back into the public. It doesn't say private property cannot be taken. It says private property cannot be taken without due process of law and just compensation. That's what it says. Private is not this superpower. It's not this superpower like people think. It is a power that you have that if you know how to exercise it in a professional and specific way, yes, it can be very, very powerful. But it's not nothing that you can declare yourself into. It is a structure that you put together.
And context is king, and we've not been doing a very good job understanding that, right? With context with this private thing, there's in different ways. Like I got this question last week where they were reading some case they came across that mentioned a private contract and everything of that nature, but they were talking about a corporation, an LLC. And I'm like, okay, there's private in a sense of not immediately engaging or directly engaging the government or some municipality. And then there's private in a sense of a non-government regulated contract. Like two LLCs can contract privately. That's still a private contract. That is what that is. Or even your employment or something of the sort. That is technically a private contract. So it's private in that context, and it's private as in not without the government. Yeah.
Yeah, it's private contract because they chose to engage in a because contract is private. However, the organizations are public because they're registered with the Secretary of State. Okay,
And that's the part where they try to blur. They kind of blur and get confused on that part where they're saying, well, wait a minute, that's a publicly regulated entity, that LLC. So how could it be private?
well, you know
Yeah,
what?
that entity can still contract privately because
You know,
private means without the government.
you know what? Let me put this on the screen for everybody and show y'all what he's talking about, because the case that really explains that very well is a Hale versus Hinkle. And let me try to explain this to everybody what he's just talking about as far as private corporations and things like that. See, you gotta if you get down to public versus private, I'm telling you, a lot of other things will just be easy for you to understand. You know, it'll be easy to understand. What is this thing? Let me see. Is this it right here? Oh my goodness gracious. No. I'm trying to pull it up real quick, but let me explain it to you. Okay, in Hale versus Hinkle, what that was is and there's a lot of cases I can show you where the judge will teach you public versus private. A lot of these case laws, the judge will take time to educate you about public versus private. Now, where is this thing at, man? Let me just pull it up over here. Golly. You know what? Let me tell y'all something. They taking a lot of stuff off the internet too. Y'all better grab as much stuff as you can, because
that is true.
They are taking a lot of stuff off the internet.
You know what else is anywhere? I'm glad I took a screenshot of it. There's something they took off the internet that used to be on the irs.gov site, and I got the screenshot, so I see it on there. Where they had the OFAL, this whole OFAL thing where it says foreign persons not required to file U.S. tax returns. But what they do have is there's another site where it says that they excluded or removed it from the IRS website, and they have all the things that used to be on there now. It's just not on irs.gov. I got a screenshot of both of them on my laptop.
Man,
so they all removed stuff from the internet.
Foreign persons are not required to file IRS tax returns. You better read that and qualify that, because let me tell you something. Anybody who effectively does business with a trade organization in the United States has a filing requirement. So if you private or foreign,
you know what that's written?
Huh? Say what?
I said, you know what that's written, OG? You know what that's written? On the same damn paragraph that's titled U.S. foreign persons not required to file U.S. tax returns. It says it right there. It's only talking about people that ain't getting no money if you're a foreign person and need an EIN.
Yeah, you know,
it's in that same thing they quote.
If you get some if you making some money, they want you to file some sort of taxes. You know,
Born or not.
Hold on, let me see.
It says it in the very same thing they're quoting, which is always interesting to me. It's like, y'all don't read nothing. Y'all saw it in bold at the caption. It said, look, it's right there. Yeah, bro, read. Like, read it. It'll tell you.
It does.
All it's saying is, if you do get some money and you do get some income effectively connected to a trade or business within the jurisdiction of the United States or connect to it, then you don't need to file for a new EIN. Just file the requisite tax form for that year and then keep using your number. And if you don't get no money, you cool. I don't expect you to file nothing. It's not exempting you from anything. I'm on the OFAL. So did you read the damn OFAL information? It's in the same paragraph.
Okay, let me read this to y'all. This right here is abatement of common law, but it has the Hale versus Hinkle in here. This is that right to travel document with all these citations. You know, when I first read this, I ain't gonna lie, it had me too. Let's see, where is it at? Hale versus Hinkle. I think it's down here. Hale versus Hinkle explains this about the corporations very, very nicely, in my opinion. Where is the damn? Did I pass it? Hold on, I might have passed it. Hold on, let me go back up at the top. Go back up to the top. Let me see. I know when I see it.
Which part you looking for?
Hold on, it's right here. It is, the first top paragraph tells you about private rights, and then the bottom paragraph talks about public rights, and it's related to corporations, what corporations are required to do versus individual. And, but it also, so right here, it is right here. It says, now this part up here is explaining the private. This part up here is explaining the public. Okay, so I'm gonna read it, the first part. This is the private side. It says, We are of the opinion that there is a clear distinction in this particular between an individual and a corporation, and that the latter, meaning the corporation, has no right to refuse to submit its books and papers for examination on the suit of the state. The individual may stand upon his constitutional rights as a citizen. He's entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state, this right here. He owes no duty to the state or to his neighbors to divulge his business or to open his doors to investigation so far as it may tend to incriminate him. You only have a duty not to incriminate yourself. He owes no such duty to the state since he receives nothing therefrom beyond the protection of his life, liberty, and property. Remember I told you earlier that the only duties that the government has to you is to your life, liberty, and property? So as long as that's the only thing we look into the government for is for our life, liberty, and property, we don't have any obligation to the country. That's the only obligation that government has to us, is the protection of our life, liberty, and property. That's it. That's the only duty your government has to you. Everything else is a benefit and a privilege. His rights are such as the law of the land antecedent to the organization of the state, and he can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are the refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under warrant of law. He owes nothing to the public. Here's what they miss. He owes nothing to the public so long as he does not trespass upon their rights. They missed that one right there. They ignore that sentence with everything that they can muster.
Completely.
They ignore it. He owes nothing to the public so long as he does not trespass upon their rights. Now, act like you don't see that. You don't act like you don't. Okay, so up on the other hand, the corporation is a creature of the state, ens leges. It is presumed to be incorporated for the benefit of the public. It receives certain special privileges and franchises and holds them subject to the laws of the state and the limitations of its charter. Its rights to act as a corporation only preserved to it so long as it obeys the laws of its creation. There's a reserved right in the legislature to investigate its contracts and find out whether it has exceeded its powers. So they not completely outside the regulated authority of the state, is my point. No corporation is. I don't care what they claim that they private or some private corporation. None of them are. That's why a private trust is the only way, because it's the only thing you can utilize that's not incorporated with the state. Is a private trust, because it's a creature of contract. And if you use a business trust, it is a business cast into the form of a contract. And contracts are protected by Article 1, Section 10, Clause 1 of the Constitution, the contract clause. That's our umbrella. You got to understand contracts. That clause in the Constitution is what keeps the government out of your business, by you conducting your affairs through contracts. But contracts have to be drafted in a certain way, because you can't put anything in a contract that violates the public law or anything in the public space. So you have to understand how to draft your contracts as well. But that's your space. Private ordering contracts, private trusts, private member associations, and unincorporated private associations. That's your playground. Contracts is the big one. Everything that you do with a private trust is conducted through a contract. If you don't believe me, get Weiss Concise Trustee Handbook off the internet. You can Google it right now and turn to the back, and you will see that everything associated with that trust is in contractual form. Everything. That's probably the freest information, best information you're going to get for free off the internet, is the Weiss Concise Trustee Handbook.
Shit should be simple. It really should be. If you just read and stop stopping early, then once you get satisfied, it's like, I'm done. Nah, read all the way through.
I think it's more than that. I think it's not just thing. I think it's also, they have to have the ability to want to look up the meaning of words. Because every time you pass a word that you don't know the meaning of, you lose comprehension of what you're reading. And then eventually it falls into disinterest, because it's hard to be interested in something you don't understand. So, that's why you lose interest. So the key to develop, if you give something, and then you have to read with attention, and that's why stopping and looking up words will do for you. Because if you read with attention, it will develop retention. Then you'll begin to retain what it is that you read. But if you're just reading something just to get through it, and you're not reading it to try to really understand it, you're not going to retain it. You're not going to retain it. You know, a lot of people quote things and, you know, just because it sounds good. You know, it just sounds good, but, you know, you got to understand, law is a serious subject. It's not a playground for the weekend warrior or anything like that. It's not. You have to be dedicated to really understanding this. I understand why attorneys go to law school for 3 years. I really do. Once you understand the structure. Now, you don't have to learn what an attorney learns, because you only need to know that if you want to operate within their space. But if you want to operate outside their space, there's no need for you to be learning procedures and all of that. You're supposed to have a contract, and if you have a private dispute, you're supposed to solve that through some sort of arbitration agreement. That's how you keep your affairs private, and you never go into their courts. True privacy and true sovereignty is you will never go in their courts. You operating in a society and in a space where it's self-governed, and that's what, like, some people like the Masons are. And these are private member associations. They have their own internal governance. If a member violates, they'll take care of it. They don't need the government to do anything. That's probably another reason why you never see them in your courts and things like that, because they got a private member association. You know, I don't know the terms of it to the extent, but a lot of them that I've already seen the organizational. I got the contracts for the Rosicrucians, and everything is contractual. You sign, just like YouTube. YouTube is a contract. It's like I don't know if I want to call it a private member association, but they have terms of service, and those terms of service is the agreement you have. That's why you can't do certain things. You have freedom of speech under the Constitution, but not when you come into this space, because you're under contract to conduct yourself in a certain kind of way. And they can do that. They can do that. And you can do it too. You can form some sort of private organization, like the Ku Klux Klan. Why do you think you have the Ku Klux Klan? Their organization, and they're utilizing freedom of association, which that's another thing people have to understand. If somebody wants to create an organization that is for white people only or black people only, they can do that as long as they are not accepting government benefits. If they're not accepting any government benefits or anything like that, they can do whatever they want to do. You can't get mad at that. It's called freedom of association. So you got to get rid of, that's another thing why people keep pumping up the racism thing. Like, I don't like that shit either. That's a trap. That's a trap. The racism thing is a trap. You're going to end up going down a road that's going to lead you into darkness, because you need to understand and respect the rights of all human beings. You have to have that, develop that capacity first, and then understand how the law accommodates all human beings and affords them all the same rights. And stop living in this victim mindset. I don't see how any man would want to even associate himself with anything like that in the first place. I don't see how a man wants to play the role. I can see how women do it, but I can't see how a man wants to play the role of victim. That's just me. But let's see. I used to think like that. Let me see. I got some other people want to come in. Let me bring some other people in. All right. This is T. Fitch. T. Fitch. Did I hit the button? Hold on. Let me see if I hit the button. I don't know. It must have came on. Okay. Thought I hit the button. Oops, shoot. All right. While the guy was on the side of, it says, if you do any business with the public, rather incorporated or unincorporated, they can regulate you and you will be classified as an association and taxed as a corporation. That's absolutely correct. That is absolutely correct. Unless you structure yourself in some kind of way. Now, you say, it doesn't matter. You're right. Whether you're incorporated or unincorporated. Now, that's somebody right there that understands something. You understand? That's a perfect, he said, if you do any business with the public, whether incorporated or unincorporated, they can regulate you and you will be classified as an association and taxed as a corporation.
Probably somebody that was just in your trespass.
Well, I mean, the only thing that I would correct on it is that if you are operating something like a business trust, but you're right as far as if you do any business, you're going to get classified in some kind of way. You know, whether it be an individual is a classification in the public. That's a classification. That's why you do an individual tax return. That's like a corporate entity, you know. So it falls under it's like a corporate soul. That's what it is an individual. So that's a tax classification. So they're gonna classify you in some kind of way. If you don't classify yourself, they're gonna classify you for you, and they're always gonna give you the worst classification. An individual is the worst classification. It's the worst one. That's what they do to you in court. If you don't allow them to classify you, they're going to give you a classification, and it's going to be the worst one. It's going to be the worst one. You always got to establish what your classification is. You know, Your Honor, I'm a natural person appearing specially, not generally, in my private capacity with the purpose of challenging the jurisdiction of the court. That right there at least will allow them to classify you and determine the capacity. And because now you're saying I'm appearing in a private capacity, and now that's going to force them to demonstrate for the record how they have jurisdiction over you. Because now they got someone who's in the private, in a public regulatory space, that's been adjudicated in a public space, and they have to account for that on the record. You know, but I learned that from understanding capacities. You know, there is I put a list of capacities. Didn't I do a video or something? I know on my website I got it. But there's a list of them that you have. They're categorized too. They're categorized. They fall from the person. It starts with the definition of a statutory term that determines what kind of person you have. That person, from that, your conduct is done. They're going to determine the capacity that person has. And then that capacity is going to get classified in order to determine rights, liabilities, and duties. That's how they do it. And all of this goes back to William Blackstone. William Blackstone, he's the one that structured all of the law. All our laws come from of England. So William Blackstone is the one that organized the law and structured it. In Harvard University, they still use that structure. The structure I'm giving you right now. That's what they teach in Harvard University. A lot of people, a lot of places don't teach it. But if you start paying attention in all the law books, you're going to see capacity a million times, classification, person. Y'all just concentrate on the word person, but you're not paying attention to classification, capacity, you know, all those things, you know. Anytime you use a word in any type of document that has a statutory definition to it and it comes before a judge, he's going to instantly classify you as some sort of statutory entity, and they're going to seize jurisdiction, and it's not going to be relinquished until the end of the suit. So, like, one of the biggest tricks is going around right now, y'all saying fund to trust. You know, you don't say that word on the private side. It's an exchanger, not a fund. Fund to trust is a statutory term that they use in the public. That's what attorneys use when they prepare trust documents. That's not what we use when we prepare a private trust that is protected under Article 1, Section 10 of the Constitution. You can't use any terms, statutory terms, in a private trust. None. None. Public and private does not mix. Public and private does not mix. You better take that to the bank. You better understand that. That's why it's one of the strongest laws. Public and private do not mix. They don't ever mix them. Don't you ever mix them. They don't mix public and private. You do.
You know what I'm saying? More and more of a need of. I mean, a real deal. It's necessary in these spaces. A culture of formal debates, not get up and start yelling type shit. But I mean a formal debate. I mean we have a premise. We have a preliminary discussion to make sure we know what each other means when they use particular terms or phrases or the impetus for saying it. Then we set up agreed upon subject matters, 3 rounds. You speak for 6 minutes, they speak for 6 minutes, 2-minute rebuttal each. Then the Q and A at the end. I think that's kind of necessary.
I got to debate my equals, and I don't see no equals out there on the landscape right now. None.
Well, that's true, but here's the thing though. When you put it, I put it like this.
On the landscape. A lot of y'all, even y'all think y'all know a lot of stuff. Let me just put it like this: you're a sharp guy, but let me say this: y'all not there yet either. Y'all got a long way to go. It take a long time to learn all this stuff. You sharp though. You're a leader amongst all these people out here. But there are certain things that y'all ain't locked down either yet, like the public versus the private. I don't think y'all got that completely locked down in y'all mind, and I can understand why. Because it's the route you take when you're learning all this. Because why would you debate with someone and they don't have a comprehension of what you're talking about?
This is what I mean, because I heard Dr. Henry Clark say it best. It's kind of what you mentioned, right? I debate my equal, all others I teach. But the thing is, but this is the thing, that's where the lesson comes from. It'll still be teaching, but in debate form, because the people who, and we know that when the student is ready, the teacher will appear. But right now, we got a situation where it's too many chiefs, not enough Indians, and these folks swear up and down and they teach us. So I'll let you pose.
How long you been doing this? About 3 years?
3 years.
About 3 years.
3 years, yeah. And I'm cold. I think I'm one of the coldest out here, honestly.
But you've been doing this 3 years. You got a lot. 3 years to me, you just functionally literate around that time, around 3 years. That was when I considered, when I've been doing this about 3 years, I considered myself, I thought I knew everything. I thought I had this shit locked down after about 3 years. I thought I had it. But you know what? There is, one thing about creditors and their bonds, I know it was in law redemption in court, dealing with presentments. He said, once you think you have it, you've had it. That intro in that chapter 1 is a very, very interesting chapter because it's really esoteric. That's what it's discussing a lot of. But he's absolutely right about that because there's levels to this shit. And, and you're going to operate, open up different levels. Like, for instance, why would I debate with someone who's never been locked up? Why would I debate with someone if I have seen the devil and they haven't?
I could tell you. I could tell why it would be posed in such a thing, raised as a form of debate. Because it's teaching. The thing is that it's still teaching, but it's people who will...
Certain concepts you're never going to get. For instance, like when you go through the system, the federal system...
It's not for them, though. It's for the audience. It's not for them.
It is for the audience. But if you go through the federal system, you're going to experience things that will reveal certain things to you that is not going to be found in a book. It's not going to be found because when you're dealing with the private side, this is what I mean when I say public and private. The court system has a private side to it. There's a public and private to everything. That's a law of nature, polarity. So they have a private side as well. That private side is not publicized. This goes on when people, when they agree to settle something out of court, they settle it privately. There's a lot of things that go on privately that you never see publicly. And that's what happens when you come into stuff like secure party and things like this. You're opening the door into a private world that you didn't know nothing about until you actually engage it and see it for yourself. Until you engage, because I know like the first time I was going through all of this, I'm like, man, I'm not sure if this shit is real. I'm reading all of this stuff, but I'm not sure. I haven't experienced any of this. I haven't experienced any of this. But I'm reading it and it sounds good though. It sounds real good. I got 3 months to prepare and I got a court date. Okay. So I'm memorizing what I need to say in court. Some of the stuff I'm memorizing, I don't even completely understand it. Like I didn't understand what holder new course meant back then. I didn't have any understanding of what that was. All right. But as I keep on reading, I'm preparing myself. And also, because I kind of want to balance everything, I'm reading statutory and case law too as well. Because I can't just completely devote myself to this and I'm not sure that it works. So I'm reading about the statutory code violation they charged me with. I'm looking at my warrant. I'm looking for things like that. And then I'm also studying this over here, this alternative way that I can utilize because I already know how attorneys get down. See, because here's your options. When you get in a criminal case, you can represent yourself or you can get an attorney or you can get somebody like us to help you. All right? You don't got many options. And I can already tell you that if you get an attorney, there's a 98% chance that you're going to get convicted. Because that's what
that's what their conviction. If I may,
go ahead.
if so, because this, I definitely want to address some of the comments. Why I say this, I see it all the time on these panels and these spaces. I clearly said a formal debate and explain the structure. This is not an argument in the case of bickering. The reason that it would be very much so necessary for an audience is because one of people's number one complaints in these spaces is I don't know who to listen to. Everybody has different information, but a lot of that information be bogus and it be bullshit. This is not because people simply like to argue. No, it's deeper than that. It's much more profound. You need to debunk misinformation so that it is out of the way of the people who are trying to operate as a collective and make a collective effort to make some actual legislative reform or some type of change in something.
Let me ask you this. Let's begin with this. Explain your understanding of public and private to me.
Do we have a particular subject matter we want to stay keen to? Because it's a very big, like a big umbrella topic.
Give me a general understanding of. Give me your general understanding of it. That's all. We just start right there. What is your general understanding of how the interaction between public and private operates? Just your general understanding of it. What you think it is.
Okay. With general, with no specific situation or context, the public is when the government, whether that be local, municipal, state, or federal, right? When some government is imposing some type of regulation or facilitating everyday commerce, exchange, laws, regulation amongst their citizens and subjects. Private is when individuals are regulating their affairs with their neighbors or whatever particular entity that has nothing to do with the actual government or encroaching on anything that they have doing, obscuring any government facilitation or agendas whatsoever. So private, in its most succinctly put, private is to you and your neighbor, your fellow man. And then public is the government and how they're facilitating society in its operation.
That's absolutely correct. And here's my next question. Okay, so if we privacy contract laws on the private side, you'd agree with that, right?
Yes, of course.
Okay, so how are we allowed to contract?
I don't know if I understand the question. How are we allowed to contract? What do you mean, how?
We just read in Hale versus Hinkle that we had the capacity to contract unlimited.
It's unlimited.
Okay.
Yeah.
All right. So can you tell me what somebody can and cannot do on the private side? Like if somebody said, well, that secure party stuff is not real, but it's based off a contract. How are you going to come into my space and tell me something is not real and we're talking about a matter of contract?
That would be a foolish person, or they're stuck on one particular context. When they say it's not real, I don't know. They're probably applying it to something that doesn't work.
Why would I argue or debate with that person when he doesn't understand the area of contract? Like when you do a secure party process, people say, well, this is not real and things like that. Who are you to say that? That's a perfect example. That's a perfect example. You know why? Because there's thousands of people that agree with the idea that it's not real and it's bogus, and there's thousands of people that will say, well, no, it's specific to X, Y, Z. Who are they to say that when we're talking about contracts?
Well, they're idiots, but this is the point. You debate it because you. But you would debate it because the fact that there's thousands of people, you get the misinformation or the misappropriation out of the way so that people can use asset protection for what it needs to be used for.
The discussion should be it's a private contract. That should be
precisely. That's the conclusion. That's the conclusion of the debate.
You know what I'm saying? Either I'm contracting in a way where I'm not violating any public laws or anything like that, that I'm following the rules of contract, offer acceptance and consideration. I'm doing all those things and I'm doing that privately. Who are you to tell me my process is incorrect? You're not. You're not nobody to tell me that. All right? That's what we're trying to say. So there's no reason. That's why you have all these different processes out here. The UCC is based off private contract law. That's what it's based off of. And it regulates negotiable. It's the law merchant codified is what it is. Right. But
what I've been seeing is that there's so much misinformation out there because we lack a scholarly process in the form of formal debate.
There's misinformation out there because number one, people don't read case law. They cite authorities that they do not read. Number two, it's misinformation out there because they won't look up the definition of words.
Yes.
So some of the primary
and it thrives because it's only challenged by way of bickering as opposed to a formal debate structure. So the person comes saying that dumb shit.
Because we could easily, put up a screen and we can pull the citations of authority and put all the law on the screen. See, right
there, perfect.
Law is not the domain law is not the domain of speculation, especially when we
It's
talking
not.
about equity. Especially when we're talking about equity.
See what you just described though is a the what you just described is exactly what I'm attempting to speak about as far as the structure of a formal debate. You get 6 minutes uninterrupted instead of somebody saying, no, take that down. No, shut the fuck up for 6 minutes. Let me give my presentation. You get a 2-minute rebuttal. You present your information. I'll rebut that and debunk that bullshit. Have we come to a conclusion now? Without cutting each other off and all this other type of stuff and ego and all this other. That's why a formal debate, there is no need for bickering. You're correct. But that's what happens when people say, nah, I'm big and bad and I got a remedy and I know it's what
I like to do that debate stuff, but let me just say this. You got to be on a certain level to debate with me. You got to understand certain things, and especially, and this is, I'm going to tell you the truth, what I used to say, and I'm going to say this to everybody. I don't think anybody in this space should be debating or you should be even teaching if you haven't been in front of a judge. I don't even think you should. I don't think you have any.
I'll second that.
I don't think you have any business doing that. And that's what we used
I'll second that.
We used to say this. We used to say, you're not a sovereign until you've been in front of a judge. So until you've taken your theories and tested it in front of a judge or something like that you're talking about, it really doesn't mean anything to me. Because I went through this, and I know I go, and so do a lot of other people. There's a reason why this information perpetuates itself. It's being perpetuated through confirmation of people who go and do things and find out things on their own. That's why the information keeps perpetuating itself. But on a large scale, the huge majority of the people are unsuccessful. You know, like like the highest, like probably 94, 95% of people are unsuccessful discharging debt. They're unsuccessful going and trying to defend themselves in a criminal case. There's a large amount of people who are unsuccessful. But there's a small contingent who are successful. I'm sorry, who are successful, and they don't have any proof of that, because when you prove it, when you go through the system, they don't leave any record or anything. You see how they do things. You see, I say you when you go through it, you'll say, I see why nobody knows any of this. I understand why nobody knows what's going on when you go through it. So I'm not going to sit there and argue with a person that ain't been through it. I'm like, nah, bro, I'm not going to sit here and talk to you about this. I'm not going to do that personally, because I understand it's been doing it a long time, because there are nuances to this information. There's an occult side of it, just like when Jordan Maxwell and Jason Whitney, when they first came out. I don't know if anybody's seen that video with the occult world of commerce. Occult means hidden, okay? That's what this is about. They hiding something from you. It's something that's being hidden. And the only thing I can conclude is the nature of it, because there isn't any money. It's having to do with the monetary system. The monetary system is a part of has to do with almost everything in this country, because the United States owes $38 trillion. So it's got its hand in everything, either in your face or behind the scenes. And that's what this is, and that's what you're going to discover. When I did foreclosures, I discovered that. Remember I told y'all the story about that banker who called me on a block line, and he's like, you fucking with the wrong, but it was Citibank. I remember who they are. I could see, even though things weren't said, and when I went through the case, I saw how, when you're doing this, you see how, like when I went into arbitration with the attorney, I saw the look on his face, like, you think this is going to go the way you want it to. It's not. And it's like they already got everything set up, and it's arranged. It's a stage show, and you don't really see the show. That's like in Creditor and Their Bonds. The original phrasing in Creditor and Their Bonds was, do not participate in public plays. Don't participate in public plays. I changed it to public controversy. But originally it was public plays, that they put it on a play for you. When you go through this, you're going to see it. You're like, damn, they acting. But that requires a level of perception, and you going through it to be able to see that. It's almost like your intuition is speaking to you. You see these things. And that is what is pushing all of this. The pushback that you see in the clapback, you have to see another thing that's been happening. Every time on this side, when y'all come up with something, they're going to adjust on their side. They're going to adjust. They're going to adjust to everything you're doing. You can't use the same shit forever and go into the courtroom with it. That's why you have to keep studying and understanding and growing deeper and deeper in your education. That's why I can't stand people who are in my chat regurgitating the same thing I've heard for the last 20 years. It only shows me that you haven't grown any. You haven't grown any. You haven't done any research. Y'all just regurgitating things from generation to generation, the same bullshit. Only a person been doing this 20 years can tell you that, because most of y'all are new into this space and it's your first time hearing it. And that's why you'll bring it to me and act like, you know, you're telling me something new. You're not telling me nothing new. You know how many times I heard that? 1,000,000 times. 90% of the stuff in this space is regurgitated information. I'm telling you. You're going to have to start really studying the law and principles of law. And what you really need to be studying is equity. Because that's where you're going to be operating. That's the space you're supposed to be operating in. That's where contracts are adjudicated. And trust. A trust is a right solely enforceable in equity. So what you should be learning, and it also teaches you how to live life. Because God judges you with equity. So that's where you're supposed to be at. You have to locate the space you're supposed to operate in. And that is that's what private ordering is. Why would I debate anybody? They don't know anything about private ordering. Why would I debate somebody about private trust? They don't know. I haven't seen not one person in any of these spaces that really knows anything about private trust. Not one person. Not one person.
I would say other than myself.
I see people use.
I would say other than myself. I agree.
Listen, let me tell you something. Trust take a long time to learn. You can know some basic things, or like, you know, I need to, you know, like some of the features, like the trustee can't, the settler, in an irrevocable trust, the settler can't exercise any type of control over the corpus or over the trustees. The beneficiaries can't exercise any type of control over the trustees. Things like that. You know, those are some basic things that you learn. You don't want to construe as an association or a partnership. But when you learn things like what we learned last night about the trust protector, you know, like how a trust protector lawfully embezzled money from a trust. Lawfully did it. And got away with it. What were the factors involved in that? Was it the drafting of the indenture agreement? Well, yes, it was. That was one mistake. That was the hugest mistake. But also the inability of the plaintiff to present any type of evidence that can be utilized in their favor. Equity follows the law. So you're going to follow the procedures of evidence and the rules of evidence. These are things that you learn, you know, when you start studying this particular subject. And if you're not brought up onto that level of understanding that subject, you know, what you're going to debate on. Because there's only one law. You know, you either understand private trust or you don't. You either understand the liability attaches or you don't.
It's more so, I would say, from what I'm seeing, right, is the people that jump on the bandwagon, the people who echo things in echo chambers, right? Those individuals are repeating and regurgitating things based off of this status or position of whoever they're hearing from. So if they were to see someone, because the debate ain't for the person you're debating, that ain't who it's for. That motherfucker already think they right. It's for the audience in specific to get more of a collective people on the right path, as opposed to seeing whoever their purported guru or favored edifier is. They can see this person crash and burn.
Let me ask you a question. All right, why you just can't show them what the law is and they not see what the law is? Why you have to debate about it?
Because they will tell you things like a birth certificate is really a death certificate.
Oh, that's true.
Because they'll say some random weird shit.
That's true. They will just say some shit.
But if they can't talk for 6 minutes and you pull up that screen that you talked about and you show a motherfucker and why you got your 6 minutes.
Why would you, like what I just did with that lady? She just said, you know, they're trying to convert she posted that thing. She said you can't convert a right into a privilege. Okay. How would you explain that to her? If you were in a debate and somebody came at you and said, well, the law says you cannot convert a right into a privilege, and then they pull up the citation of authority that says it, that you cannot convert a right into a privilege. How are you going to explain that to them?
I'm going to pull up the actual case, and then we're going to look at the actual case. Then I'm going to show you why you think that says that, and I'm going to show you why you're wrong, and I'm going to show you what it actually says, and then I'm going to show you when a right cannot be converted to a privilege, and what you're trying to apply that to isn't what it actually is applying to.
But wouldn't you have to understand public versus private? Because we have to understand what rights what rights are and what privileges are, and where privileges operate in and where rights operate in, wouldn't that person have to have an understanding of that? If they don't have that understanding of public and private, of what the space that privileges operate in and the space where rights are operated in, how are you going to explain it to them in an understanding way? If they don't understand the space it operates in. If they
in order for them to have the deepest...
If they think that the public space, in the public space, they can exercise a private right.
If they think in a public space you can exercise a private right, then they're doomed. If they think that, but we can show someone why it is that they can't.
Why would you prove that though? See, like this is I'm just trying. I've been doing this 20 years. I got Facebook groups, everything. I've been talking to people. I've been talking to people a very long time. I'm telling you what the number one thing is. The number one thing is people don't understand the difference between public and private. And if you don't understand that right there, it's a useless cause to get into a discussion. Because you're going to be citing statutes, doing all kind of things that probably are not even germane to the discussion, and bringing in things that you don't even know that's not even the right application of what it is that you're like.
Correct.
You're citing 18 USC 271 and 272, conspiracy against rights. You know, you still citing statutory codes and bringing that up. But I'm sitting here talking about contracts. But you want to talk about using code sections. You still on that?
And see, that's why in the two parts is why I mentioned you have to have a preliminary discussion to make sure we're not talking past each other to see if a debate can even take place. But then after that, again, the debate ain't for the person you're speaking to. That's probably a I'm stuck in my way type of person. It's for the audience.
You can go get your people and everything. Y'all want to do that? That's fine with me. I probably need to do a good debate. I need to do a good debate.
Because I've watched people.
I need to do it.
I'll watch people, right?
Hold on. Yes, I agree.
Like the equity dude.
The equity.
Was it?
Let me tell you something about equity. Equity, I don't even know what to debate about that because equity is a set of principles. So I only see that, to me, the only way really to learn equity is to read case law. You got to see how judges apply equitable principles in their decision. Equity guides everything. Equitable principles guide everything in equity. Everything in equity. And equity is fairness, impartiality, and even-handed dealing. So all the principles, that's what they're doing. They're trying to create fairness, impartiality, and even-handed dealing. That's what all the principles do. And there are a lot of them. There are a lot of them. A lot of them. So that's what I'm trying to say. If somebody say, well, they understand trust, I'm like, you didn't learn all those equitable principles? You've mastered all those principles of equity. Because see, trust is a creature of equity. It's a right solely enforceable in equity. So you have to learn equity and understand how to properly administer a trust, how to properly draft an indenture agreement. You know, how much power do you afford a trust protector? Do you want to put a corporation as a trustee? What are the advantages and disadvantages of doing that? You know, there are things like that, and you know that what the only way you would know the answer to those questions is reading case law. When you read a situation, like for instance, like last night, they were dealing with a trust protector. Okay, the trust protector, he wrote the indenture agreement himself. He was an attorney. The guy was quadriplegic, and he won. He hired the attorney. They won the case. He got like $1.2 million. I guess the attorney talked him into getting an irrevocable trust. The attorney drafted the trust. He appointed himself as the trust protector. As the trust protector, he gave himself very, very few powers, just to remove, replace, and resign. That was the only powers he gave to himself: remove, replace, and resign. Okay, that was it. So he made sure that he couldn't be held liable for any type of administration oversight of the trustees. That was written in the contract, because in equity, the judges are going to stick to the contract because we have to get the intent of the settler, which is represented in the contract. Well, anyway, he later on replaced the trustees with a friend of his who has a law firm who they do business with. And he became the trustee, and he's the trust protector, and then they began embezzling money from the trust. When they came in and tried to prove it, they tried to bring action against the trust protector because they went to the trust protector and told him that they were embezzling, and he didn't do anything. And so when they tried to hold him liable, he was like, look, in the contract, I can't be held liable for that. See, now, when you experience something like that, now you know how to hold the trustee to a certain level of liability because he made sure that he didn't have almost any liability. And that's because he drafted the contract. But if you understood trust law, you would know what powers to delegate to a trust protector in order to make sure he has a duty and also corresponding liabilities. Because everything with a trust indenture agreement has to be expressly written. There can be no ambiguity. Everything has to be cogent. You're going to only learn that through reading case law. And you're not going to learn that through a weekend. You're going to be spending about a good year studying case law to make sure you're going to become a master of trust. You're going to put in your 10,000 hours just like everybody else. This ain't no weekend shit that you can learn because you know what a trustee is, what a trust corpus is, what a settler is, what trust capital units are, what units of beneficial interest are, what a trust protector are. Just because you know a couple of phrases and everything, that don't mean you know this space. Trust me on that.
That's fact.
What happened? What happened to my screen? Oh, hold on. I done turned the screen around. Hold on. Let me switch this around. Flip camera. Okay, I'm sorry, y'all. Got my camera turned around. But you know what I'm saying? So it's like, that's what I'm on real hard right now. I'm on the trust. I'm on the trust.
It's a dude. I would say this, right? If there is a dude. I don't want to say if there's a dude that has the eyes and attention of an overwhelming majority of people interested in this space. And quite literally, this is not my opinion. This is not speculation. This is not conjecture. Mm-hmm. Everything I have ever heard him say is emphatically, unequivocally incorrect. He needs a debate because you cannot pull something up. I did this on one of his lives. He allowed me to come up. I asked this person, hey, when you say exclusive equity, what is it that this means? If you mean it's void of any positive law, why is it that you have 4 different uniform commercial codes on your so purported special deposit? Why is that there? I see him mouth the comment and then ignore it and then move on to something else completely incorrect. Now, this person needs a formal debate where you cannot interrupt anybody for 6 minutes in XYZ. Because you know what he mentions? If you remember Tyrese, when he was going through his whole child support thing. And what was purported with him was say, hey, Tyrese, tell your people, get to my people, because this is what you need to do. You need to pay your child support by way of a private trust. What do you say? An Article 3 trust under the Constitution. But so people was crazy as hell about it. I'm going to say this for the audience too. I want y'all to really think about what I'm saying. If Tyrese has to pay his child support through a trust, just stay with me. 70 bands out of his own pocket, he's going to effectively get to the trust so the trust can give it the child support. So far, Tyrese is still out 70 bands. But this is why he proposed it. Because when the trust is going to pay for the damn child support, now the trust has the right to equitable subrogation. And according to this person, what equitable subrogation actually means in this instance is that it doesn't mean that you're going to ascend to the shoes of the state who is owed the money. No, he believes what this means is the person who, the surety, right? The person who's secondarily liable for, in this case, the trust, once they satisfy the debt obligation for the principal debtor being Tyrese, they're entitled to reimbursement. But this motherfucker thinks that the state has to reimburse him as opposed to the principal debtor. That's what he thinks. Well, so he believes.
That right there sounds like that they biting off the 1099 OID process. That's what it sounds like.
He wouldn't mention no tax documents. The thing is, he incorrectly.
I mean, there is.
Well, that's the problem. Okay, you're not. You're not going to get that reimbursement.
Well, let me say this. When you look at the UCC, okay, there's first of all, to understand when we're dealing with negotiable instruments, it is mandatory that you understand holder in due course and what a holder is. Okay, we have to start right there. UCC 3-302. Okay, you have to understand what that is because that's going to channel into UCC 3-305 and UCC 3-306, which are claims and recoupment and claims to an instrument. Because see, everything you're dealing with is a claim. So you have to have a claim and then you have to have proof of claim. The only person entitled to receive recoupment or have some sort of claim to the instrument is the holder in due course. So you have to understand, well, to retain that status, how do you have to conduct yourselves as it relates to any type of commercial transactions that you're engaged in. And that's going to require to give notices. That's going to fall under UCC 1-202, which is notice. So you have to give sufficient notice of your first of all, your interest in whatever the negotiable instrument is. All right, and that's why, like, when you do this is why I love the secure party process, because it teaches you all that. See, like, when you issue a negotiable instrument, you're supposed to put it on a UCC3. The reason you put it on a UCC3 is because that's a claim on it. You're checking the box that says collateral add, and you're adding that collateral to your property on the UCC1. Okay, that's a form of a claim that you're having on this negotiable instrument, so it affords you this claim in recoupment and it's claim to an instrument. Okay, but you have to be a holder in due course and able to do that. Now, if you read UCC 3-302, it tells you all of this. It tells you.
See, now that
all of this.
He would be less daft and less of a dullard if he actually took that position. But the reason he's an absolute moron is because he believes that what he can subrogate to, what he's getting reimbursement from, is the state, when in reality, equitable subrogation compels the principal debtor to pay the surety back. That's the subrogate. Yeah. It don't. So he thinks, let's wrap this up. I want y'all to think about how crazy this shit is and why he charged what he charged. It's fucking crazy. He thinks that if he gives $70K to the trust and allows the trust to pay child support, the state through child support is going to pay him back. That's what he thinks. This makes no sense. He thinks this.
What trust is paying the child support? This was, I guess, is throwing me off.
His private trust.
Okay, so he's paying child support. Okay, so how's the private trust paying the child support?
He's going to give his own trust $70K as trust corpus, and then the trust is going to write a $70K check for damn child support. So now he think the court going to pay his ass back after they just got the damn money.
I don't know.
Yeah, crazy as hell. So let's pretend he actually tries to do equitable subrogation. You know what this is actually going to, in real life, yield to? Stay with me. Now that we know what subrogation actually is, they're going to say, okay, principal debtor, pay the trust back. Even though if you had a trust, I would assume you wrote the trust to satisfy debt obligations of the beneficiaries, who I would think would be a principal debtor, but that's if you're smart. So let's take that away and just use his particular setup. If you went and tried to enforce equitable subrogation, goofy motherfucker, you gonna owe your trust 70 more K. So now you out 140, you dumb, stupid.
I'm gonna tell you this.
He needs a debate.
When they said subrogation, I remember when they first started using that term, subrogation, and they just recently started this exclusive equity. You know, they go into the law books and they find terms and start throwing them around. This is what I see. I'm gonna tell you, when I hear all of them talk and I see what they discuss, I see that they have taken a lot of theories from the old school and modified them. If they've been modified, you know what I'm saying? Like, for instance, the secret treasury, the secret treasury account. There was never in anything that I read when I first was introduced to this about a secret account at the Treasury Department. What it was is the account was the bond that you send to the Treasury Department with the tracking number on it that could be referenced, right? Which would also, you gave notice that they were the holder of that bond and you were the holder in the course of it, and then that there was an implied trust agreement that was created. They took that, and that's why they called it a UCC contract trust account. You'll probably hear people use that term. Okay, but that's the reason why it was called that. When what people did was, and also you were looked at as some sort of surety for the straw man, that you're subrogating in for the straw man, and that is the language that is in the bond agreement, okay, that you're making with the Treasury Department. So when they started using this term, I could see where it was the same thing that they were trying to do in the old school, but they gave it these new modern terms. See, the secure party process is really should be called just private banking. That's all it really is. It's just a process that somebody came up with to discharge debt, where you could have a statement of account by making claims against instruments you're going to issue. That's what, so that would fulfill the requirements under UCC 3-302, UCC 3-305, and UCC 3-306, giving proper notice that's going to fulfill the requirements of UCC 1-202. And then all of those, and when you're dealing in private negotiable instruments. Now, if you've ever dealt in that space before, you can see that, yeah, I see how, like we just did a case where an attorney in Washington State, he filed a lien against the state, he's an attorney, he filed a lien against the Washington State Bar Association. He went out and monetized it overseas in Greece, started selling pieces of it. And how he was able to get away with it is that he put the bond in a safekeeping receipt in a bank. So when they tried to verify it, they could only verify the safekeeping receipt with the bank. And so once you understand how that negotiable instruments work in that world, you can see how you do this stuff like that, how people monetize debt. At the end of the day, there really isn't any money. There's only collateral or value that is established that people agree upon on collateral that can support debt obligations and that way. But also there are also instruments that are not securitized, that don't have any collateral supporting it. That operate in commerce too. So, so when you understand how the rules operate and how the UCC works, you'll see, man, I didn't make secured party creditor. I did not make that shit. But whoever did is extremely intelligent. I can tell you that. You might think it's a game when you see that bond and you say, what is this? Somebody put $100 million on it and all that. But if you get into the real world, they do that every day. They do that every day. The only reason it's not real to you is because you don't understand the rules of the game and you're not operating in that space. So you don't understand. You think it's some type of fanciful, made-up type of process. When it teaches you securitization, everything that I've learned, I see when I look at that process, I see. Now I'm gonna tell you this. I also see where I can make it better. Where I can make it better. I'm at a point now where I can look and see that the people that put together, I'm like, this is kind of like, I don't think I would do it like this right here. But I understand why there's a registered mail number on a negotiable instrument, because that's a tracking number, because that's what a CUSIP number is. A CUSIP number tracks a security under the ABA. But we're on the private side. So we have to have a CUSIP number to track, because we just need to know who the holder of the instrument is. We don't need to care what they do with it. We don't care what they do with it. I just need to know who the holder is, because I'm the holder in due course. And you're only the holder in due course if you have fulfilled all the, what they call perfected and interest in property by doing the proper steps to do that. It's a rule book. The UCC is just the instructions to the game. There isn't any money. We're in a debt-based system. Everything, debt is being used as money. Debt is being used as money. And this is the reason they have all these charges, because a charge creates a debt obligation. A charge is a lien on property. So if you have a lien on, they tell you this right there in Georgia, OCGA 1711-1, tell you very clearly, when you're convicted of a crime, they put a lien on you for all cost. Okay, well, how much is that? Does anybody know? Do you know? Not either. How much is that? We read 1711,
what was that?
Put a lien on you. How much is that lien for?
I can. You said I heard. I didn't hear the first part. Between what? What was that?
I said in OCGA 1711-1, they find you guilty. They put a lien on you. How much is the lien? Anybody can look this up right now.
I don't.
Look up OCGA.
I don't know all the debtor's property. I don't know what dollar amount.
Exactly. Don't nobody know the dollar amount. Nobody knows.
Yeah, just say all the dead defendant's property. I think it says something like that.
That's under the criminal rules of procedure. So somebody, if I'm in a debate with somebody, how they gonna answer that? How they gonna answer? Okay, what is this lien? It's a rule of criminal procedure. Okay, right here they just confirmed they put a lien on you. Matter of fact, when you read down when you get the book off the shelf from the law library, you're gonna see where the judges also say, well, all them sandwiches and everything you get fed in jail, okay, you paying for that. The sheriff is not paying for that. That's part of the cost that they put a lien against your attachment against your property against. So these are the things that, like, when you really get into this, unless you've been through it, they don't really understand what you're talking about, y'all. They really don't. They really don't.
And that's what needs to be exposed.
They don't understand.
That's what I think needs to be exposed. Right. That's exactly what I think needs to be disposed, especially when somebody pull up and say, we know a lot of brothers are afflicted with are burdened by child support obligations. So when you advertise that and you got a buzz and you got a following and people think you like that for real, you advertise some stupid shit like that and it's like, yeah, I'm gonna fuck with you. Just run me like $5,000 for this private whatever trust. That motherfucker needs to be debated so that the audience can see, oh shit, he getting his boots smoked so that we can shut the misinformation down. That motherfucker needs to be debated.
He got a lot of people. Well, I'm not actively just hunting people down or anything. But if you want to put somebody, want to come in a forum, I don't mind engaging people about these subjects. I've been doing this for a very long time. It's not a problem at all. I've been doing this for a very long time.
I'm just thinking in a healthier space, because for us
they're
to
talking about that exclusive equity, like trust is a creature of exclusive equity. Trust is. A trust is a right solely enforceable in equity. So equity, just like some of my students will ask me sometimes, well, shouldn't this be conducted in an equity court? Aren't they I say, first of all, they merged law and equity in America, number one. Anytime a judge is adjudicating anything related to a trust, equitable principles are being utilized. Anytime, because you can only adjudicate trust with equity. So that is something that is a right solely enforceable. That would be exclusive equity domain, But I don't know, I don't know exactly how he's trying to use the term, but it's like that's.
Well, I asked him, and then he didn't answer it. I asked him, he didn't answer it. Things he says it's outside of positive law. So when I ask him why you mention so much positive law, he just doesn't. He mouths it, reads it, and then moves on and doesn't address it. So it's bad.
And that's how you know a beginner, because in the beginning, when you haven't quite understood public versus private, you're going to be quoting a lot of statutes. You're going to be on
and that's the thing.
Side.
That's the thing. You said it's for a beginner, but he's like the most popular person moving.
Somebody said that to me in the beginning, and I didn't really understand it. They told me that. I was doing that. I was quoting a lot of statutes and doing things like back in the day when I was fighting foreclosures. I knew public and private, but I didn't have it clearly defined. I didn't really understand it to the level that I understand it right now. But I understood there was a public and a private, but I was still trying to, use public remedies. I still was mixing. I would come in, like I'd issue a negotiable instrument, but then I'm trying to use statutes to enforce it and things like that. You know what I'm saying? I'm mixing the public and the private, and you can't do that. You cannot do that. The public, you got to understand, the public courts are there just to enforce public policy. Okay, these are not constitutional courts. When you go into a statutory jurisdiction, it's not like they're not there to adjudicate private rights. They're just there for enforcement. That's why y'all use this this you don't have jurisdiction over me, because once they get you in the meat grinder, it's going to be some money that they're going to extract from you, or some time, or something like that, because everything in the public has been monetized. You can put that in ChatGPT. Everything in the public has been monetized. Everything in the public is monetized. That when you come into the public, it's almost like, if you can imagine, this is the private and this is the public. When you come through that line, as soon as you come past that line, all your activity is being interpreted and narrowed through statutes now. All your conduct, anything that you're doing. As soon as you pass over that line from private into public, that's how they got it set up. Any conduct you engage in, anything is being interpreted through a statute. Anything. Okay? So this is why you have to understand how to maintain privacy is to stay on the private side and not mix the two, unless you do so in a controlled manner. And doing it in a controlled manner is when you're utilizing certain entities like corporations, private trusts, things like that, and you understand the tax consequences that are associated with the utilization of that entity, as well as the conduct that that entity was engaged in. I have never read any material on private trust where it says you don't have to pay taxes. I just haven't.
I would ask you this, OG. So people, this is something I guess is relatively confusing to people. If you make a private trust, you effectively make it. You make the indenture, the corpus, all the Schedule A's, everything about the trust protector. It's a creature of your own creativity. You would agree?
Yes, it is. You can mold a trust,
and it will impose.
Hold on, let me give him.
And it will impose no obligation on the state.
Let me give you the principle. You can mold a trust into any form that you want. That's a principle, right? You can mold a trust into any form you want. It depends on the drafting of it. See, you can make errors in your drafting. This is what the Uniform Trust Code is for. The Uniform Trust Code is a default provision for people who draft their trust. They don't account for some sort of event, something that could possibly happen. See, the difference in between people who are experienced with trust and people who are not. And I showed my class this last night because my mentor, who's been doing this for 25 years, she gave me a trust indenture agreement, like 45 pages long. And I showed them the difference of instructions that you give to a trust protector from a person who's been doing it 25 years versus one who just generated something on ChatGPT. And
so if you were to make a private trust, is there anything that you can put in your document that would compel me, non-ether, to do a damn thing absent of a contract between that trust and myself? No. Is there anything you could put in that trust?
No.
Okay. Can't. So that would be the same for the state then, correct? That would be nothing you could put in your trust will impose an obligation on the state, right?
You can't impose any obligation unless you enter into some sort of contract with them and they have.
There we go.
Right,
unless there's a binding element between the two parties. So with that being said, it would be completely irrelevant what could possibly be in your trust. Completely immaterial.
You're telling me they're going out there telling people they can form a trust and it makes some sort of obligation on the government? Is that what they're telling people?
Well, that's the implication when the point of contention is, well, we have to know what's in somebody's trust corpus or indenture or trust instrument as a whole in order to qualify whether or not the state won't have an obligation to pay back child support. It don't matter what's in that document at all, not even a little bit.
It does.
It's completely immaterial if the point of contention is that trust going to be reimbursed by the state? The only thing that will control that is a contract between the state and the trust.
That's one of my students, we got into an argument. He was trying to tell me that his trust pays the state and they're obligated to pay him back. And I was saying, because he said if he gets pulled over, he can charge for his time. He's going to hit him with
the fee schedule.
And
them unenforceable ass fee schedules.
And I'm like, I said, well, how are you doing that? I said, you're operating in a public regulated space. You violated a public statute and you charging them. So basically, you telling me that you have a right to do anything you want to do. That's what you're really kind of saying to me in a roundabout way, because you're basically saying there's a liability attached to them stopping you because they didn't have a right to stop you. Isn't that the inference? Am I making the right inference? Or, because how are you charging them, hitting them with a fee schedule? And he was telling me how he's going to enforce it through the taxes, but I didn't like it because I'm saying, okay, you're saying they don't have a right to pull. So let's say you're driving 100 miles an hour through a school zone. They pull you over to prevent you from killing somebody, and you're going to hit them with a fee schedule? See, it's things like that even a long time ago, I would always question them on this right to travel thing. I'm like, okay, so you're saying to me, because as somebody doing this, I had a client one time, this dude, he came to me, he just got 8 years in prison. And it was for a DUI. And a DUI carry up to a year in jail. So he said, man, the judge is corrupt. The judge is tripping. Can you help me? I'm like, what's up? This judge just gave me 8 years in prison for a DUI. I'm like, damn. I'm like, the judge is tripping. I said, because I had done DUI cases already, so I knew how much time it carried. So I said, let me see your paperwork. So he bring me his paperwork. And I'm reading the police report. I'm reading his case. Because I always make people give me their police report and everything like this. So the first thing I'm going to do is read the police report because I want to see what happened. Okay? So in reading the police report, he's driving. He's drunk, real drunk. He done got on the highway going the opposite way of traffic on the expressway. The police catch him and pull him out the car and beat his ass and bring him in. All right, he got, he get his ass. So he upset, and I'm looking at this, and so the judge gave him 8 years because number one, the cops gave him 8 tickets. So the judge ran each of them consecutively, and the reason she did that because this was his 8th DUI. So now I'm going to pose the question to all you right to travel people. What should the judge have done? We got an individual who is irresponsible. He's a public safety hazard. Okay. He if the judge doesn't take action against him, he goes out and kills someone, maybe your daughter or your son, and then you find out that this person had gotten 8 DUIs Well, okay, wouldn't the first thing come out of your mouth why you didn't stop him? Wouldn't that be, if that were you, if that were your children? All right, let me tell you something. I had cases where people were drunk and drove through somebody's house and drove into the children's bedroom and killed the children. Or you say you got a right to travel? That you don't need to fall under any regulation? See, these are the stories. In the position I'm in, I hear a lot more than you hear. And I had to reevaluate my stance. Because at first I was like that, all angry at the government and shit. But then I started to see some motherfuckers need to be locked up. Yeah. I started to see that. I said, some of y'all need to be locked up. If you create a 501c3 church and put the car in the church registration, then get a DS-11 travel passport and use that for identification when you're traveling around in that car on your church work, nah, you can't do that. You got to have a driver's license. Still in a public regulatory system. The only way that you are going to avoid that is you have a driver. That's why wealthy people have drivers. You need to have some bread to be a sovereign. Let me just put that out there. You ain't gonna be no sovereign and be a broke motherfucker. Okay? That's just not working. You gotta have a little bread. You know, you need to because you need to, that's why they have drivers. That's why they have drivers. You're not circumventing public regulation when you're operating something that could possibly kill somebody else. That falls under public safety. It's not happening. You're not going to circumvent that. And you can never completely get out of the jurisdiction of the country. As long as you're territorial present in a state or you're present in a country, they have some jurisdiction over you. Maybe you have narrowed it a lot. You can narrow the scope of their jurisdiction over you dramatically, but it's never 100%. That's only my point. You could probably narrow it down to like 95%, but there's still going to be about a 5% jurisdiction that they're obtaining over something that you engage in just by you being present in the country. Just by you being present. Like if you kill someone, ain't no, you don't have jurisdiction over me. They got jurisdiction over you. Ain't no, you don't have jurisdiction over me. That's not working. That's not going to work. How about the judge that gave someone who killed a child and the judge gave him community service? I don't know nothing about that. See, y'all say shit like, and then see, they'll do that a lot. Where's the case? Put a link up. Let us look at it for ourselves. Because they always try to demonize the judge. They do their best to try to demonize government every time. They don't take any accountability. Like, for instance, in the foreclosure debacle, okay, I was in the heart of that between 2010 and 2013. Prior to that, I was a real estate investor. So they were doing no-doc loans. Everybody was taking advantage of it. Everybody was buying houses. People were inflating appraisals, pulling money out, not doing the rehab work on the houses. All kind of stuff was going on, especially in Atlanta, Georgia, because you know that is the home where everybody wants to be a hustle and everything is about a facade of what you got and what you look like in Atlanta, Georgia. All right, so when they started to reel all of that in 2010, y'all started talking about how corrupt the banks were. But wasn't nobody talking about all the corrupt shit y'all was doing. Y'all stealing everything that wasn't locked down when they were doing all those no-doc loans. I'm just saying, why is no accountability on your side? You got to understand natural law. What goes around comes around. The universe is about balancement. If you do corruption to get equity, you must do equity. There's a reason why Lady Justice has a sword in her hand and she's blindfolded and she's holding up scales. That's because some high initiate embodied the principles of nature into that statue. That's Mother Nature. And Mother Nature favors balancement. And she is unbiased. She got a sword of justice. And she's blind because she's not a respecter of persons. The law operates on everybody equally. So if you what goes around comes around. Do unto others as you would have them to do unto you. If you steal a piece of candy out of the store, something is going to get taken away from you and your life of equal value. You don't get away from anything. And that's what long life will teach you. It will teach you to stop looking for ways to get around things, under things, and over things, and learn how to go through things. Learn how to take the proper steps to do things correctly instead of trying to look for some way to get around something. That is the mind of a thief, of a criminal. There are steps to everything. There's no shortcut to success. I'm sorry, did you say something else? Somebody else want to come in. Let me bring some people in. Who is this?
Now, why you looking for some others to bring in? Man, I was just saying, all that. I agree with you and Dr. Clark. Right, you debate your equal all others you teach. I was just simply mentioning that the formal debate structure is a slick way to teach a motherfucker a lesson that need to be taught. That don't want to pose as a student is the kind of the point.
It is. That's why I said I'll do it. But at the same time, that's what I was just saying. Like when you talk to people, I've been talking to people for a long. I used to debate for 7 years straight on high frequency radio. People called in 3 years every day for 3 hours and talked to me. I did that for a long time. Trust me. The thing is that you know, when you talk to so many people, you see where their understanding is, and they're going to stick to that understanding because what I see in this space is they haven't, because they haven't understood certain principles, underlying principles of law, and they're applying their area of expertise of knowledge in a way, but they are leaving out this part right here that would have you know, that would affect materially what they're trying to do right here, but they're ignoring and that's what I see that's going on. Who did I just let in? Who is this? Go ahead, brother. I opened up your mic. Go ahead, brother. Who is this?
I don't know if they know the mic was on mute. It was open. You go. You back.
Yeah, you go ahead, brother.
Okay, hey, yeah, so kind of like new to the space, hearing a couple different things. I'm just trying to understand the principles, as you say, and such. But yeah, so it's been said that I guess Article 1 courts don't care about, or constitutional rights don't apply, but also Article 3 courts are there to make sure that Article 1 courts are doing things constitutionally, but you have to exhaust your administrative options first and stuff like that. So I'm just trying to understand how all that stuff works.
Okay, that is a very good question.
Maybe it's kind of like messy of a question, but
no.
I'm just trying to wrap my head around. Yeah.
That's a good question. Well, first of all, to understand that, you have to understand separation of powers, where the judicial power is deposited, which is in Article 3. And you have Article 1, Section 8, Clause 9 that allows, and this is on the federal level, I'm just giving you federal right now. Article 1, Section 8, Clause 9 allows the legislature to make courts. Now, separation of powers applies on the federal and state level. All the states have a legislative, executive, and judicial branch of government, and there are checks and balances that form on each, and there's a separation of powers. All right, you got to understand that first. All right, so once you understand that, you'll know that it's called the political powers doctrine or political question doctrine. A political question doctrine means that the Supreme Court, they have to defer to the political branches of government when a matter falls within the purview of their delegated powers that come from the Constitution. So the statutes all represent the legislative authority, okay? Now, they are in an appellate capacity because they are there to ensure that no constitutional violations occurred. Now, however, the procedures are put in place to ensure that doesn't occur. If you go to the law library and you pull a United States Code or United States Code Services or United States Code Annotated off the shelf and you looked at the introduction, you'll see that the procedures are approved by the Supreme Court. The Supreme Court reviews civil procedure and criminal procedure to ensure that it's constitutional. Right? So this is why when you do an appeal, right, when they do an appellate review, they're only looking for procedural defects unless they do a de novo review. But they're only looking at procedural defects in the case. Right? That's why they do that, because in the public, everything runs by procedure. And yes, you have to exhaust your administrative remedies. The reason that they tell you that is because that falls under the powers of Article 1. So they can't infringe on that because of separation of powers. So they have to let Article 1 do everything that they can do, and then only once when that comes to an end, then you call upon them to take a look at it. Now they have something called what is it? I'll think of it in a second. It's called the doctrine. It's these 7 constitutional principles that the Supreme Court looks at before they will even take cognizance of a matter. You know, and one of them is whether or not that you have been an acceptor of benefits and privileges. You cannot have been taking advantage of a benefit or privilege from government and then denied the corresponding liability that is associated with that benefit and a privilege. That's another reason why it falls under the political question doctrine. You have not been operating solely in a private space. True Article 3 protection is only afforded to individuals who are truly operating in a private space. They're the ones who are afforded true Article. Almost nobody in the world today is like that. That's why that guy wrote that article, "The Republic is a house no one lives in." He's absolutely right. Everybody is a U.S. citizen, or everybody's taking some sort of benefit and privilege from the government. You work a job. You got a social security number. You got bank accounts open. You got all these. You got personal bank accounts open. You got automobiles in your name. You're doing all kinds. You're enrolled in school. You're doing something like that. All that is a part of the public. All that is a part of the public. And that's what people don't understand. And that all falls under Article 1. All of the public falls under Article 1. The private falls under Article 3. Article 3 protection. If you look this up, ask ChatGPT, does Article 3 courts protect private rights? Let's pull it up on the screen right now. Does Article 3 courts... Hold on, let me see what this is. What you're talking, Article 3 courts, Article 3 courts of the Constitution create the federal judiciary court. Let's see right here. Yeah. And you still have constitutional protections on Article 1, you know, like you got the clause.
Right.
Having all that noise in the back. Can you mute your mic, please? Mute your mic, please. But does the Constitution, do Article 3 courts protect private rights? Yes, Article 3 courts are primarily the courts that protect and adjudicate private rights. Understanding this requires knowing the historical distinction between private rights and public rights in American constitutional law. What are private rights? Private rights are rights belonging to individuals in their private capacity. Your Honor, I'm a natural person, appearing generally, not specially, in my private capacity for the sole purpose of challenging jurisdiction. Private rights are rights belonging to individuals in their private capacity, typically arising from property ownership, contracts, torts, trust relationships, fiduciary duties, and inheritance and estates. These are disputes between private parties or between and that's another thing, like when I did the secure party process, they have a estate planning section on there where you get an estate, you get a court, and you get a 9-8 number. That's so you can arrange your estate privately. Man, let me tell you, whoever put it together, it was put together very nice. It's people don't understand it because it takes a long time to learn it. And that's why a lot of people don't engage it, because it takes so long to learn it. But when you learn it, you'll understand why everything is there, it's done the way that it's done. Whether it's effective or not, that's another question, but you can see how it is in alignment with securitization, private banking, negotiable instruments. It's within the rules. Everything is within the rules. It says these are disputes between private parties or between the private party and the government where traditional legal rights are at stake. Historically, these matters are handled by courts of law and equity. Article 3 courts inherited that role. What are public rights? Public rights involve matters arising from the government's regulatory authority, regulated space, including tax assessments, custom duties, immigration, Social Security benefits, administrative licensing, and regulatory penalties, like selling dope. These rights exist because Congress created a statutory scheme. Because they are creatures of statute, Congress can assign their initial adjudication to administrative agencies or legislative courts, which is what they do. Everything in the statute, it gets put into Article 1. As soon as they're through adjudicating everything, then you can call on Article 3. But separation of powers won't allow them to infringe on the obligation of the political branches of government. The political branches of government are Article 1 and Article 2. You can Google what I'm saying right now. Just Google public rights doctrine and political question doctrine. Political question doctrine.
Right.
These are all the doctrines that
right. So
use. Go ahead.
Right. So I guess that's why, like, I mean, one of the principles you talk about is like, public rights are above private rights. So they're trying to like rule out.
Public rights are not above private rights. Public has its own domain. But private rights begin where public regulation ends. I'm not saying they're above one or another. It's just that they have a space they operate on, and the private has a space it operates on. But a lot of y'all try to operate in the public space and then assert some sort of private right. I'm not saying that public is above.
Oh, yeah.
I'm just saying you gotta know what domain is what domain and how to act when you're in domain. Like your mama said, boy, learn how to act when you're in the public. You know how to act when you're in public?
Yeah.
Learn how to act in public. It's an act. When you come into the public, it's an act. You got to learn how to act in public. A public actor. You know, you can't do the same things in the public you do in the private. Okay, let me tell you this. Y'all can get William Blackstone commentaries and Rights of Persons and read those first chapters and see what they say about public and private. This going all the way back to England. And it's still consistent 300 years later. What I'm saying is not modern. What I'm saying goes all the way back to Rome. This shit I'm telling y'all go all the way back to Rome. I ain't making this up. It's like 1,000 years of law supporting what I'm saying. Public and private. All law is public or private. Put that in the chat GPT, see what it tell you. All law is either public or private. See what it tell you.
Yeah, so one thing that I also heard was that judges don't care about case law that's before Erie Railroad.
Oh,
Well,
that's what I'm telling you about. Yusuf.
That's coming from the UCC connection with Howard Freeman. All right, that's where that came from. He's the one who said that because in the Erie versus Railroad Tompkins decision was in 1938. And that's when they started using, I think it was state commercial law or the UCC. That's where that came from. Is out of that. But let me tell you,
real quick, OG. Sorry to interrupt you. Somebody in the comments is saying that YouTube, they can't hear anything on your YouTube. There's no sound on it. That's what they're saying.
Okay, okay. It must have happened. Okay, it must have happened when the microphone switched. Okay, can y'all hear me now? Y'all can hear me now, right, on YouTube? Y'all hear me now? Okay, I hope y'all can hear me now. Okay, they ain't hear me now. All right, so let me say this. You got something called good law, okay? Good law means that it's still, like for instance, we use case law all the time from the 1800s on equity. Equity is not changed at all. You know what I'm saying? I know who said that, Howard Freeman. But you have bodies of law that, this is what common law means. It's a body of law. If you're using that body of law and it's still called good law, I don't see why it cannot be used. There's a term called good law. This is why you shepherdize the case. It'll tell you whether or not it's inapplicable anymore, or something like this. But you shepherdize the case, but is it good law? Write down the term good. That's a legal term, good law. Know what the term good law means. So if it's good law, I mean, yeah, you can use it. Let me read the good law to everybody. Define good law. Good law. Define good law. Good law means that a judicial decision is still valid and authoritative because it has not been overturned, reversed, vacated, or superseded by later legal authority. So that's all you need to know right there. All that stuff right there, then a list of the cases before 1938. I have never seen any evidence of that. And besides, it doesn't matter because if it has been superseded by something, they're going to let you know once you learn how to shepherdize the case, whether or not it's still good law. That's all you need to know. Is it still good law or is it bad law?
They're letting you know that your mic volume is low on YouTube.
My volume is low on YouTube. Okay, I can't.
That's what they say.
All right, let me just put my mic right here because all right, I'm gonna keep the mic right here. I can't tell. I'm looking at the levels and it seems like to be coming through loud and clear. Oh, you know what? Let me see if I can raise this up. Check, check, check. Check, check, check. All right, how's that right there? Okay, that might be better right there. I think that'll be a lot better. All right, that should be
yeah, you right. Good law is good law. It doesn't matter where you're coming from.
If it's good, it's good law. You shepherd. If it's still good law, I mean, you know, that's the answer to that question. You know, they say that, but they got that from Howard Freeman and the UCC connection. The UCC connection.
If we're also going to be practical too, judges don't just have a litany of case law in their mind ready to spit at all points in time, right? They're going to have to go look that up. So when we say they don't care about law that comes from whatever particular year, they don't know that.
You're supposed to be the one to introduce a law into evidence file, not the judge. You're supposed to give him controlling authority. The judge is not supposed to. You're supposed to be in the law library digging all this stuff up and bringing it to him. And you should know how to shepherdize the case and make sure it's still good law. You know,
and just in the sense and sake of being practical, right? You're not, if you're in open court and you cite some case, it's not like they're gonna say, "Oh, that was from 1929." Like they're not gonna do that, so that's not really a thing for. Okay. They don't know that.
They say it sound better on the internet. Finally, okay. I'm sorry, y'all. I'm sorry. Yeah. I apologize on YouTube. I'm focused over here on TikTok. Because I got my TikTok channel through my mixer, so it's coming out on YouTube too, so they can hear our conversation on YouTube. All right, so so this is a nice way to have interviews. I'm like, well, shit, I don't even need to. If I want to do an interview with somebody, I can just bring them on TikTok, and I'm gonna try to find some way to see if I can channel the video from my TikTok into my YouTube. I think I can do that too. I'm pretty sure I can. I just got to figure out a way to do it. It says, sometimes useful lives are low when you use a laptop. Okay, yeah. His phone speaker was bleeding over to the mic. Now, what it was is I had something muted on my mixer. I just unmuted it and it opened it up. So I'm sorry about that, y'all. I don't know why I got to remember that. I really need me an engineer, but I'm home because I'll forget some stuff. Because see, this setting that I had it on at first was good for my class last night, So, but then this setting is good for YouTube today. So I got to remember to change the setting. That's all that was. I apologize. Let's see what we got. Like you said, Rome spread this out, and when he sent other Europeans out around the world with their manifest destiny. Well, yeah, I mean, we're going to have to talk about this more stuff too in a little bit. Let me bring in somebody else. Who is this? Solomon.
While you letting that brother in, somebody asked, what is revocation of election? It just literally means you're choosing to be, you're electing to be of a different particular tax status, or you're taking back a tax choice. That's all revocation of election is. It's nothing deep. Form 8832.
Yeah, you have, I immediately went into trust terminology, and choice of law, choice of law when you determine where your citizen is going to be located, and, you can change that, but I'm not a tax expert. I have a CPA for all of that. Get you a good CPA. If you're a businessman, get you a CPA. You have your business, get you a good CPA. That was the best business advice that I ever received, was to get me a good CPA. Because when you start making money, okay, you need to have someone who is a certified public accountant that will do the taxes for you. You are not in the public. That is their domain. Let them do their job. That's some good advice. All law is private law. Public law is 51% of the population operating under some private law. That's not it at all. See how they just make up shit? He said all law is private law. Public law is 51% of the population operating under some private law, namely statutes and codes, the government-private trust terms. You just made that up. That's just some shit straight out of an echo chamber. So when you first come in, you're going to hear people talking like that. He can't substantiate nothing he just said. Let me say it again. All law is private law. Public law is 51% of the population operating under some private law, namely statutes and codes, the government-private trust terms. You know what? I'm going to tell you this.
I didn't make no damn sense.
I'm going to throw him a bone. I actually did research kind of on what you're talking about. What you're trying to say is that the territorial jurisdiction the federal government operates in is kind of akin to being private. What you're really describing is what's called plenary power doctrines. Why don't you incorporate that into your vocabulary? It's called plenary power, where they are all powerful within their domain. And so I juxtaposed that with ChatGPT, but it said it wasn't. I forgot the answer, but it gave me a very intelligent answer. And but that's not correct. It's not a private domain. But that's what you want to do. That's what ChatGPT is good for. It's good for analyzing information, comparing and contrasting things. And then it'll give you a result. Because what you just said right there don't have no basis in law and fact at all. It's just some straight echo chamber. What we have to do, what I'm here to do, I'm here to kill all the echo chamber rhetoric. That's what I've been sent to do. I'm here to put you on the correct path of law, to get rid of all these wild, fanciful theories, everything that's going on in this space. And ChatGPT is here to ensure that the people who actually do research are the ones that are elevated, and the people who are opportunists and charlatans, they get exposed. Because you can't fake 10,000 hours of study. You can't fake that. You can't fake that. You can only get by for so long on, using, fake shit, You either know or you don't know. He said, hey, God, did he pull that out of his, they quote me, now he pulled that out your ass. I don't know, it's just some echo chamber stuff. He said, like you said, it said use of okay, it's low. Let's get back. He said, you also got the clean hands doctrine, the fruit of the poisonous tree. The fruit of the poisonous tree is what they use in unlawful search and seizure. Okay, now they have a right to do what's called Terry frisk you, to search you for weapons, but they can't go in your pockets and things like that. It's just a pat down to make sure that you don't have any weapons for their safety. They do that. But, if a search was, as a result of an arrest, I don't think it's going to be, because a lot of guys used to come to me with that fruit of the poisonous tree. My thing is this. I'm going to give you some street advice. If you selling dope, you a businessman, okay? You're a businessman. Okay, why y'all can't act like businessmen? That's what I want to know. You saying it's unlawful search and seizure, but they found the dope they were looking for. They found the dope. You say, you gonna be riding around with some dope in the car and money and smoking a blunt, knowing that they can use the smell of the blunt as a probable cause to search the car. I never understood that even back when I was hustling. I never understood it. I'm like, why would you do that? You sound like an irresponsible businessman. You know, a lot of stuff you do is self-inflicted. You know, you go into the jewelry store with a big wad of cash. Why don't you just get you take that big wad of cash, get you a prepaid credit card or a secure credit card, okay, and every time you make a purchase, make it through the credit card. Now, you're not only establishing your credit, but you don't look like a damn fool going into the jewelry store. You got your credit card, you going in there like a businessman and paying it like that. You can get way more mileage off credit than you can cash. But they go hand in hand. You know, I don't understand, and as far as what was that other doctrine you was talking about? Clean hands is equitable. You know, you have to do equity in order to get equity. Clean hands doctrine is very important in equity. Very important. Very important in equity. Very important. Clean hands. You can't get equity unless you do equity. Equity is a very precise field of law. It is, it's a beautiful field of law to me. Once you really it's composed of principles. The principles are what you have to learn. It's like learning equity is like learning how to play chess. That when you learn how to play chess, you got to understand what the rook is for, the knight, the bishop, the king, the queen, the pawns, what their values are as well. You know, what piece is more important than the next piece. And then you got to learn how to put a strategy together with it. Like for yesterday, that attorney who embezzled that money, he understood equity. He put a strategy together to actually help him embezzle money by eliminating liability for oversight of the trustees from him by limiting his powers. It was intentional all the way. Now, if you didn't, when you study this subject, you probably would never even know anything like that could be done unless you actually read a case where somebody actually did it and you study and analyze how to get away with it. Let me give you another case. There was a case where somebody, Ron LeGrand, he used to always say, you cannot, if you can't make money without money, you can't make money with money. He would always say that, and that's an absolutely true statement, because if you have no money, you can go out and look for an investment for someone to make some money with, take it to them, and offer them and let them give you a cut of the proceeds, even if you don't have the money to fund it. Like in bird dogging and real estate. That's what I did. I actually went out and did that and had no money and made $5,000 from nothing within 30 days, flipping a house where I did an assignment of contract. But those type of things, you know, that you can't make money without money. I forgot what I was talking about. Somebody want to remind what I was talking about. My mind, you know, my mind must be getting old shit. Must be getting old.
I got another quick question.
Yeah, go ahead. I'll bring somebody else in. Go ahead.
So when you get a ticket in the mail, you get the ticket like in person and stuff like that. So if you don't respond to it within, the delegated amount of time before they give you, a summons or respond in 10 days and that kind of stuff, are you already defaulting, or are you in dishonor? Are you already in dishonor and are permanently the debtor in that scenario all the way up until the summary trial and like all that stuff?
Okay, well, let me ask you this. What's the adverse of going into default? If you let's say that you answered within the 72 time frame, what is supposed to happen when you do that? What status do you have then if you answer within the appropriate time?
Staying in honor and having a chance to stand as the creditor.
If you stay in honor, what does that mean?
You, I guess, have the capability of calling the shots or having the upper hand.
The upper hand. Okay. Well, there's something called acceptance for honor. Have you ever heard of that term?
From you.
Okay, acceptance for honor. All right. Well, being honorable means that, yes, that you have basically adhered to the clean hands doctrine, because everything that you're going to be doing is adjudicated in equity. All right. So it means that you are procedurally correct in everything that you have done, that you're procedurally correct. Now, as far as, I don't know what you're talking about receiving a ticket in the mail, because you get a ticket on the spot from the law and from the officer. They don't send you a ticket in the mail. Well, maybe they do in some.
Well, they send you a summons in the mail if you don't, if you don't respond to it. But I'm saying
the ticket is the summons. You should have signed the ticket in a certain capacity, is what you should have done. How did you sign the ticket?
Well, it's a parking ticket. It was a parking ticket, so it just appeared.
Oh, it was a parking ticket. Oh, well. I ain't gonna lie.
Yeah.
If it's a parking ticket and it's a private company, I don't even worry about it, because how they gonna enforce it? They can't enforce it. If
What do
it's
you
a
mean?
private company. Now, if it's a state, you got different type of parking tickets. You got private parking lots, and you got, the parking tickets.
True, yeah.
You got different kinds, But yeah, I mean, what are you talking about? Just honor it. Do what you're supposed to do. You're supposed to pay it. You go discharge it. Do everything everything is according to a time frame. So yeah, I go by 72 hours. Yes, you want to do everything within a 72-hour time frame. I guarantee you.
Right. So if you're not like continuing to stay in honor the whole entire time, you don't have a chance of keeping the creditor position, like upper hand position,
they got
right?
Something called curing a default. I know you say you listen to me, so I know you know that you can cure a default, which means you can correct the procedural errors in it. But usually when what's happening is the first side, both sides usually go into dishonor, which leaves the judge, carte blanche to do whatever he wants to do. But you want to stay in honor. You want to do staying in honor just means you do everything procedurally correct. And answer that correspondence within 72 hours. Yeah, I ain't going to back down off of that. Yes, answer within 72 hours. I don't care if they give you 21 days. For instance, like if you do the Fair Debt Collection Practices Act, you got, I think, like up to 21, they have up to 21 days to respond to something. Or they may tell you that you have 2 weeks to respond or 30 days to respond to something. I always respond in 72 hours, and I get a different reaction from them when I do it that way. That's all I know. I can just tell you from experience how that is. That everything operates off of a time frame. And you have something called latches in equity. Time is of the essence. But they usually have procedural time frames attached to certain type of things in statute when you're dealing with a statute. But I always use 72 hours as a rule. That's what I use as the rule. There's nothing written down on that. Because some states don't have because in some states they have what's called a cooling off period. That's for where you can get out of a contract within 72 hours. And then in some states they don't. The rule of 72 is a mystical number. But that gets into another conversation.
Yeah, but
I always wanted to know, creditor to who? When we say become a creditor, you're the creditor in a traffic ticket situation. Who are you creditor to?
Okay, let me explain that. The creditor and debtor situation, a lot of them don't understand this either. Because none of them talk about HCR 192. The reason you're the creditor is because of what happened in 1933 with the taking of the gold. The underlying question is there an expectation of return of that gold? And when they took that gold, who are they taking it for? Okay, if you took the gold of the citizens, is that being held in trust? Was there some sort of constructive trust that was created to prevent unjust enrichment? Was that unjust enrichment? That's the ultimate question. Because the Constitution dictates that only gold and silver be used for satisfaction of debts. But that's only in the Republic. They put together something that operates in a territorial jurisdiction. That's Article 1, Section 8, Clause 17. All right, that's why we get back to that plenary power doctrine. Plenary power, okay, that operates within, they have a Federal Reserve Act, a contract that was made with Congress that falls under their purview. They get you, if you want to participate in that jurisdiction, they give you a social security number, and you voluntarily participate. Ain't nobody making you participate in their system. It's called a Federal Reserve System that they have that you operating in. So within that system, they use dead currency, Federal Reserve notes, which don't have any intrinsic value. All right? Everybody agrees on that point. They'll even tell you that nobody's hiding it. All right? However, you have to have permission to other instruments within that jurisdiction. If you're going to issue instruments within that jurisdiction, you need permission. And that's why the first step of the secured party process is establishing a contract with them. You just can't arbitrarily go about and start issuing negotiable instruments. There's a process that goes through with that, because they have the right to determine what is money within that jurisdiction. And you're calling yourself the creditor because there's an obligation owed to you. The straw man is in the public. You're in the private. There is no value in the public because the public is bankrupt. So the value of your labor is what is supporting your instruments that you're issuing from the private side. And you're the creditor of the United States only when you're in a private capacity, because the United States owes that gold back to the private man that y'all like call the real man. The straw man is a debtor entity because it was created by the debtor corporation. Now, isn't that what you were told? That's what you were told, and that's why you're called a creditor. But you're a creditor only if you're acting in a private capacity, vis-a-vis the government. That's why they call you the creditor. And the creditor has to honor his obligations, because in that bond that you sent to the Treasury Department, you gave instructions, but you also established duties on yourself. Do you know what those duties are? Do you know what those duties are?
To accept obligations that have, well, I guess, to accept offers to contract.
Okay, you're pretty astute. So you see I'm pretty consistent in my explanation. It hasn't changed one bit, has it?
No. And I'm talking about this in reference to creditors and their bonds, because I just went through the whole entire thing.
Right.
And I'm just trying to test not test, but, try things out on like low stakes environment, $100 parking ticket, like that sort of thing. And I'm just trying to.
You know what you should start out with? You should read Using Your Exemption by Moses Washington and really listen. That's what I did. And I started out with there because this is what's going to happen when you try to discharge debt. Okay, leverage comes in. Okay, how much leverage do they have over you? Okay, you trying to discharge your electricity bill, you don't have any leverage. They'll cut off your electricity. You got a little leverage with a car because they have to. Now, there's a clause. I'm going to tell you what happens when you try to discharge a car. They're going to assume that the collateral is in jeopardy and accelerate the loan and try to come and pick the car up. So if you're going to discharge a car, I would never try to discharge a car unless I put that car up in storage or something like that until the matter had been resolved through litigation, after I litigated it, because they will come and get that car. Now, they tell you that even in Cracking the Code, the third edition, they explain that to you. A house, there's a lot of leverage with a house because a house is very difficult to take from someone. If you try to discharge it when you're current on the payments, you got a lot of stuff to fight, because you can do an administrative process and then file a quiet title action on them. You know what I'm saying? Now, depending on the mortgage company, that's also going to depend on your success level too, because if it's like a major company like Citibank or something like that, you're probably going to have a very difficult time. But if it's some small company or something like that, you might be able to have some success. We've had success and things like that. You can have success. You can, trust me, it works. It does not work en masse though. It's not going to work like 100% of the time or anything. I've never seen anything work 100% of the time. If you had something that worked 100% of the time, that person would be rich. He'd be fucking rich, because he'd be selling that shit hand over foot, and everybody would be coming back saying it worked every time. And then let me tell you something else. If he did discover it, it ain't going to work no longer than 2 weeks, because they're going to cut it off, because everybody's going to be on the internet talking about it. It ain't going to work. It ain't going to work long. A lot of stuff used to work back in the day that doesn't work today. A lot of stuff worked back in the day. I don't see as many things working today because they're ready for things and y'all not growing the space, meaning that the UCC is for creativity. So we don't have any more Douglas Riddles coming in on the scene telling you how to convert a voucher into a negotiable instrument. because y'all only using processes that somebody else was using 15 years ago. And some people are attempting to create some new things, but they're not really as diligent in their studies of the law as they were in the past. See, in the past, we didn't have any choice but to study because wasn't any social media. Wasn't a lot of stuff on the internet. We had to go to the law library. We had to read books. You know, we had to do things like that. We had to look up words, and we had to actually physically have the Black's Law Dictionary and actually look up the words if we want to know the meanings of it. That a lot of people are detached from that right now, and they're lazy, and they depend on other people to tell them things. You're like, now you should, first of all, you should know how to construct a negotiable instrument properly, lawfully. You should know the process and presentment of a negotiable instrument. You should know what evidence you need to have and what procedural mechanisms you need to know in order to make a lawful case for yourself when you go to court. You got to know all those things. You just can't, I gave him a negotiable instrument. He should have discharged the debt. That shit is not flying nowhere. You just wasting your fucking time. You better be ready to go to court. If you ain't ready, if you're trying to discharge debt and you're not ready to go to court, I don't know what you're doing. All roads lead to court. So if you're not ready to litigate what you're trying to do, you might get lucky every now and then and they send you a title to something. That happens. You can sometimes send a negotiable instrument in, and that might be an error on their part. Who knows? But yes, people get titles and things like that. It happens. It don't happen on no big scale, but it does happen.
So when you're responding to the ticket, you don't want to plead because that gives them default jurisdiction. So where do you sign? Like, what do you do?
I don't know. I don't know what you're
And if you plead
about.
not guilty, then you're arguing and you're in like dishonor, right?
Well, yeah, you are arguing. If you're arguing something, you
Right.
said that you're going to accept the charges for value and consideration. So you just said that you understood what your job was. Your job is to accept it and discharge it. If you're doing that process, so that's where the acceptance for value came from. You're going to put an acceptance for value on it, which is called a banker's acceptance. And then you're going to send it, and then you're going to accompany that with a negotiable instrument, because the banker's acceptance is not a negotiable instrument. That's not a negotiable instrument. And you attended a negotiable instrument with them, and then and that's what it is. That right? You're not arguing anything. You accepted charges for value and consideration, or value for assessed value and consideration and discharge. You're not arguing anything. It's a presentment. You said you read creditors and their bonds, right?
Yeah, but I didn't actually start any processes with like. No. I read it, and I know that I have to read it a couple more times because this is like it's like learning this stuff.
It admonish you all through there not to argue. That's one of
right,
the
exactly.
things in there. Not to argue.
Yeah, 100%.
Not to argue.
100%.
I mean, let me tell you something. Creditors and their bonds is a process that you have to go through. That's one of those processes, like when you go through the court, you realize it's real. You're like, God damn, this shit is real. That's one of those things. Like when you're studying it, like that's the first thing I started studying. And let me tell you, like there's a part in there that talks about bond. They talk about bonds a lot in there. And talk about replevin bonds, all type of bonds. And the hot potato game is where they talk about how liability shifts from the prosecutor to the defense attorney to you, to the straw man to you. Okay, when you know that and you study the record, and because what it is what you're going to find out is that everybody's trying to avoid liability. That's the big issue. So in the public, they don't want any liability for anything. That's the number one thing you got to understand. Especially when you're looking at who signed their signature on documents and things like that, you're looking for who is liable. Because if a prosecutor brings charges against you, well, there's a liability attached to that, because what if you didn't do what he says that you did? This is when, like in Georgia, we have OCGA 1711-4, the liability of the prosecutor. And when you read that, you'll understand why they don't throw cases out. Why, all the cases seem to go through probable cause, 100%. All of them. When you begin to understand liability, you'll see why. You'll begin to understand it. The commercial nature of the space is what you have to confirm, and that is the reason why you're asking the question: is this civil or criminal? Because they're going to say it's criminal. Okay, well, it's not that you're trying to find out if it's an admiralty jurisdiction. You're trying, because admiralty is civil in nature. It's not that you're trying to find out if it's admiralty. You're trying to find out if it's civil. Because if it's civil, it's about money. And this goes back into the statute merchant, debtors' prisons, penal actions, which are today modern, penal actions, which are criminal in nature, but they're civil in nature, but they're criminal in their proceeding. It's a criminal proceeding. So that's what you're trying to determine. And you're only really going to understand that when you start studying admiralty and how admiralty proceedings operate, and then see how they adopted those proceedings and incorporated that into their statutory scheme. And ask some questions also. Obviously, when you go in there, you got to ask questions. You got to ask the right questions. When you ask the right questions, you'll see how they act. You'll see how things go. You'll be like, damn, I can't believe this shit they're actually doing this shit. You'll actually see some things. But, you won't know until you actually do it for yourself. They got it set up real nicely where confirmation only comes through actually doing it. Not through third parties and things like that. They don't allow you to present any evidence of things out to other people. That's not going to happen. I'm just telling you, and that's why this space has gone on for so long. I understand why they ask, because people will say, well, that's a bullshit, or this is bullshit. There are a lot of things that are bullshit. I'm not going to lie. But there are some that aren't. But would appear to be bullshit, but the only way you're going to know it is if you go through it. And that's why a lot of people who go through it, they see that and they ain't going to ever let it go. And you ain't going to convince them otherwise. But that's where that public and private, because like a lot of people out there, what's really pushing them? They got a glimpse of something and they keep looking for an answer. It's an answer that they think that they need to get more and more information. It's something that they're missing. And that's why they're jumping around from guru to guru. Because it's something that they're missing, but there isn't anything missing. The rules are laid out. All you have to do is read. Most of them have never read the UCC. Most of the failures are coming because they don't read the instructions. You're going to use negotiable instruments, but not read the instructions to negotiable instruments. I find that very interesting. And they know you haven't read them. And a lot of the procedures and the maneuvers they use on you comes from that, like according satisfaction by use of an instrument. A lot of people don't read that. So they don't know this recontracting that everybody talks about that comes out of that code section right there. But if you don't know the rules, they know most of y'all don't read the rules. They know the overwhelming majority of you don't. You do a process and then come back and ask somebody what to do next. You never should have been doing the process in the first place. The first time I ever did a process, I knew how to do it beginning to end. I'd have to come back and ask somebody what I do next. That right there also tells me that you're only in it to take care of an issue. You're not truly interested in learning what the law actually says. You just want to take care of some exigent circumstance that's present in your life, and then you're going to be in and out on it. But what you're supposed to be studying is a lifestyle. And you're really only discharging debt to leave the public, not to try to take advantage of the public, because they're not going to let you destroy the public, collapse it. You think y'all going to go in there and discharge everything in the public? That's not happening. That's not happening. All right? Get a hold of yourself and come back to reality. That's not happening. You should be using discharge debt. Your house is getting foreclosed on. You're about to get it and put in prison or something like that, not to pay utility bills and credit cards and shit like that. I didn't come in here on that shit because I'm a dude who always had money. So it's like, I got a wealth consciousness. I can attract it to myself for that. I need to protect my freedom and my property. But y'all trying to live off the shit. And that's not going, you can't live off of this like that. Not like that. Not like that. Nah. You can't live off. You'll pay your utility. Now, there are methods, like, for instance, 1099 OID. That's a real-ass process. That's a real process. All right? However, a lot of people abuse it, and a lot of people get arrested. A lot of people, I've seen everything with my own eyes, talk to people, all kind of stuff. I had this one guy come into my office, right? He did a 1099 OID process. He was not involved in this space. He came in there with his wife, and he had got like a $350,000, $375,000 check. Actually, the check was originally like $550,000, but he owed back taxes. He owed back taxes, and he owed like back taxes and $80,000, and the IRS deducted the $80,000 that he owed, and then gave him the rest in a check. Okay, I took a copy of the check, and I know I got it on my computer. I got to dig it up. I know I got to have that damn check because he let me photocopy everything that he had, and I photocopied everything they had. So he explained to me what happened. He said, man, he went to a seminar, and I got the copies of all the seminar documents on SPC University too. Exactly what they filled out, how they filled out, and everything. I got all of that. And he went to a seminar, and they told him about this OID process. He did it, and he got a check, but he got a visit from the IRS. He got a visit. And there was a couple of people who from that seminar came to visit me at my office. And I'm going to tell you the difference between the two. The first dude, he was a real happy-go-lucky guy. He was like, yeah, they came to my house. He was kind of like goofy, he was kind of like a guy that seemed like he was always happy. Like he was just always smiling. He was like, yeah. So I'm asking him, I'm saying, I said, so what happened? He said, well, they came to my house, and I told them, come on in. He said, invited them in, offered them a drink. And he said, the first thing I asked him was, is this stuff real? And he said that the IRS agent told him, yes. Now we want to know who told you it. So they came to find out where he was getting the information from. Now, that's why I don't teach it, because almost everybody who was doing seminars got arrested. Because see, I read the case law and other gurus and things like that. So they were getting arrested. They were looking for them. They visited this other lady. She got like $550,000 or something like that. And she came to visit me because they had charged her. All right, they was giving her a criminal charge. And she was a black chick. And what she told me happened, they came to visit her, she cussed them out. She was telling them, you don't tell me what to do. Use all that shit that y'all try to use in the chat and things like that. And she said that the IRS agent told her, I'm going to make your life miserable. And she ended up getting like, I think, 2 years in prison or something like that. And there was some other people who came to visit me as well. But the thing I want to say is there's a lot of people who have gotten checks, and there are a lot of people who have gone to jail, and a lot of people haven't gone to jail. Watch out for the individual that's doing the process that's getting money off of your process. In other words, okay, he's going to do the process for you. You're going to get a $300,000 check back, and he's going to get $25,000 of that. Okay, so he's going to do that for about 8 different people. So now he got $200,000, but he don't have no risk, because sometimes that stuff comes back about 2-3 years later. 2-3 years later, he's out the picture. He got his money and gone. But here you are stuck with the bill, going head to head with the IRS. That's something you gotta, that's something you gotta be aware of. It's a lot of little things that dudes maneuver in spaces to make money and things like that. And, but a lot of that got cut down because now they got, the computer system has changed a lot with the filing of the 1099 OID. So, but there are people that are still doing it. I know for a fact. And, it's just a space. I don't operate in that space, but it's a space that if you want to operate in, it's, I don't know if it's hit or miss like that, but I do know that there is some legitimacy to it, I guess is what I'm trying to say. There's some legitimacy to it. I've had bankers come to my office and talked to me about it, where they were putting holds on checks, on Treasury checks, for 30 days, and it still cleared. And that was why they came to see me. They said, man, we put holds on these things for 30 days, and they still cleared. And he said the checks were going through for like 9,000. He's giving me some insider information, and it is what it is. I don't choose to mess with the IRS. I try to stay in a nice little space. See, I already dealt with the federal government. You got to understand, I went head to head with the federal government for some years, and it cost me a lot. It cost me my family. It cost me a lot in dealing with the federal government. And I like it in my life right now. They can stay over there. I stay over here. I do everything the right way. I don't try to invoke the ire of the federal government. I respect the power that they do possess. You would be wise to do that too, because if the federal government ever gets their hands on you, you're going to really see, they're going to take those masks off, and you're going to really see who they really about behind the scenes. And you don't want to be going through all of that. So, just be cautious when you do certain things. My job is to keep you out of jail, so I'm not going to tell you anything that's going to get you arrested, even when it's dealing with negotiable instruments. I'm not going to tell you to do something that's going to get you arrested. You need to understand what the law says and how to properly move before you do anything, instead of going out there and just trying to, start issuing instruments and doing all kinds of things like that. You should be at least dedicate yourself to 24 months worth of study. That's just what I feel. At least 24 months, because that's what I did. I didn't go out there and just start issuing instruments, and I only been doing it 2 months. Why would I tell you to do that? You know what I'm saying? I didn't do that. Why would I tell you to do it? I didn't, in 24 months, start issuing instruments. I was still studying. I didn't know what a UCC3 was for. So just some recommendations. He says, but you just said they operate on an assumption, presumption. See, that, look, you just said they operate off assumptions and presumptions. I don't know what to say to that. I don't even know, do you understand what I say when they operate off assumptions and presumptions? And those are called rebuttable presumptions. We can rebut a presumption. All right, that's what status correction is about, rebutting a presumption. Feds are dealing with the mental plane. The state is dealing with physical plane, money, and usually, listen, the state, just understand, the state is doing what they supposed to do. They supposed to, everything they doing everything the right. I remember another guru said that to me. He said that the government always does everything the right way. What book was that I was reading? It said the government ever does everything right. It was, I don't know if it was Judge Dale. It was some document I was reading where another guru said that, and he's absolutely correct. The government does everything right. Now they may obfuscate. Are they evil people back there? Yeah, I'm not saying that. I'm just saying is they operate with plausible deniability all around the board. So that's why when people try to say they corrupt, they are like, man, shut up. You just don't know the law. You don't know enough. That's all that is. And you just frustrated because they can outmaneuver you because they know more procedural law than you. They know how to function in that space, in the public space, better than you do. That's all it is. That, like last night with that case, it was obvious it was embezzlement, but they got whipped procedurally. And they're going to call the judge corrupt. But everybody in my class could see the judge wasn't corrupt. It was this pro se litigant coming in here that don't know procedural law, don't know rules of evidence, don't know rules of court, don't know principles of law, didn't understand, didn't take accountability for the construction of the indenture agreement, gave that to somebody else, and then lost $1.2 million. And yes, they're going to be saying the judge is corrupt, the judicial system is corrupt. But anybody who knows law and studies the principles of equity can see 100% the judge was 100% right. The judge tried to help the person. That's what is the problem in this space. There's no accountability, and everybody want to call everybody corrupt. I done lost a lot of following because of the message that I'm having right now. There's a lot of people that, since I ain't talking about the government is corrupt, everything is on them, motherfuckers ain't got on. You do need to get the fuck on. I don't care either, because I'm separating myself from y'all because y'all are ignorant. That is ignorant what you're doing. That's ignorant, man. You trying to blame the government for everything. I'm not no anti-government protester and all that shit. I'm a businessman. This is commerce. You're supposed to be demonstrating that you are competent enough to handle your own commercial affairs. Not at every turn talking about, oh, they hijacking our rights. And you ignorant. Nah. You got to take time to learn. That's the problem. The problem is y'all want something quick and easy. That's why you sitting here asking me about a damn traffic ticket. You trying to figure out how to discharge a traffic ticket. You don't even understand creditors and their bonds. Let me bring somebody else in. Forneo. Then I just hit your button, didn't I? Yeah, there you go right there. Your mic is open. Forneo, did I pronounce that correctly? I don't know if I pronounced that correctly. It said, be more inclined to keep going with the space. The truth that they said use of government will not make it easy to be private. They don't like it when you steal because you don't like competition. They don't like it when you steal. Listen, you don't have to worry about what...
You can hear me?
Yeah, I can hear you. Hear you clearly. Go ahead. I can hear you. I can hear you. I can hear you. Your mic is open. Your mic is open. Okay, he got off. I guess it was something wrong with his mic. Let me bring in Solomon. I'm just going down the road. Solomon. Next is Orlando. Well, I guess he got off too. Orlando. I see y'all in queue. I'm pushing the button. Can you put the Constitution for the United States in the university? Are you asking me for the difference between for and of? Is that what you're saying? Let me tell you something. You can't almost find no copies of the for on the internet now. Back in the day, you could. You can't no more. All of them is of. That's why y'all talk like that. I'm telling you, man, they take so much shit off the internet. You can't believe the amount of stuff they took off the internet. Y'all wouldn't believe it. That's why I don't even engage in that conversation right there. Because I'm like, wow, they took all this shit off the internet. They didn't change all the constitutions over to this right here. Put it in ChatGPT and let ChatGPT explain it to you. I did an article on it in ChatGPT. Then I can't find it anywhere. I know you can't find it anywhere. I just said that. You can't find it anywhere anymore. You used to could find it, not anymore. You ain't been able to find that about probably the last 5, 6, 7 years. The government as the body operate. See, that's why y'all will question things like that. And it's like, what are you going to tell you? It's like, hey, look, just understand that you don't need to even understand that. That's not even important. It's not even important. What's important is you understand public and private and territorial jurisdiction. It's really not important because they both read exactly the same way. It's not important, though. The government as the body operates correctly, but the people involved may not be morally correct. A person will do wrong if he or she can and feel that they're backed by powers and they get no consequences. That's what they believe, but they can do that all day long in a private space as long as they don't bring it into the public. The problem is they think they can come into a public regulatory space with that attitude. That's the problem. You can do whatever you want in the private. It's in the public. And that's what William Blackstone says in his thing. See, this thing about the Constitution, the Constitution of the United States is like a corporate charter. See, now if he would get a Black's Law Dictionary and look up the definition of Constitution and look under what's called parliamentary law and can see that deliberative assemblies use constitutions to form like municipal corporations and things of that nature. All right, so there's an organic constitution, okay, as well. And if you look at the difference between the preposition for and of what it applies to. But there is a guy, he have the original Constitution. It is, you can get a copy of it. I think it's like in Arizona. He got Bono's Law. I got the video. I think it's on my video. It's on my video. The secret jurisdiction, the secret maritime jurisdiction exposed. I think it's on that. I got a part 1 and part 2. And I think if I remember correctly, it's either that or it's on the Judge Dale, the Matrix in the U.S. Constitution. I think it might be on the Matrix in the U.S. Constitution. Either one of those videos, there's a video on there with a guy, he actually got the copy, because they will give you the copy. It's I think it's preserved like in Arizona or somewhere like that. And he says, because the original 13th Amendment was different as well. It said that attorneys couldn't hold office. And they removed that and put down the 13th Amendment with the slavery. There's actually a copy of that you can get. But and like people have called over there and confirmed it. But they say you can't enforce it though. He was talking about they got the guns, you can't enforce any of it. But there's some truth to it. That's all I'm trying to tell you. It's just that, I've been doing this for a long time. I'm not sitting around concerned about 2 constitutions. I got other shit, really, and really and the thing is, you got to understand public and private. It doesn't matter what it is, because you don't even need to be concerned with the corporation unless you're receiving a benefit and a privilege from it. So if you're not receiving a benefit and a privilege from it, why are you concerned about the constitutions? I'm not concerned with that, because that's not within my control, and I'm not concerned with things I can't control. I'm only concerned with the things I can control. The government as a body operates correctly, but the people involved, it says, I know I'm wrong in a lot of things, but from what I've learned from you, Yusuf, government ain't as innocent as they make themselves to be. No, I didn't say that. I'm not trying to say that they are. I'm trying to say is you need to operate with clean hands and not worry about what government does. You need to operate and do everything you're right, because you create your world. You don't have to worry about government if you're doing everything you're supposed to be doing correctly. Don't worry. You gotta stay in the bounds of things you can control. I cannot control what the government does. I can only control what I do. And I understand the universal principles. So to make sure that my life doesn't incur some kind of hiccups, I need to understand, first of all, how to think correctly, because thought is behind everything, and what's called constructive thought, and start creating the environment that I want. That's what you need to be concentrating on. That's what private sovereign individuals do. Create an estate for themselves that they can operate in to their liking. That's what the private ordering is all about. But that's going to require you to build that. You can't go into something already built and start asserting certain rights that you do not possess. We have to get that correct first. You want to start talking about this. We can't even talk about discharging debt because most of y'all don't understand public and private. You ain't got that down. You ain't got that down. So, and then besides, you need to have a business. You need to do some other things too. Where's your business at? You trying to discharge debt, you still working at a job. Y'all tripping. That's this generation right here, though. That y'all y'all done took it to a totally different space. Let's see. Can I ask? So, if my labor is given to the person, I have ever been paid. He copied that out of a document that you never been paid. So I guess that's where that recoupment comes in. That you never see. We used to say that too back in the day. That if the energy for my labor, if I'm really not getting paid because I'm getting promises to pay. So the gold and silver is supposed to really compensate me, and that's why I'm the creditor. I mean, if you want to say that, you can say that. Most people don't understand the basic process of giving notice. They don't. They don't. That's definitely one. That's a big one. That's a big one too. The notice requirements, that's a big one. That's a big one. Yes, it is. I know I'm wrong in a lot of things, but I agree with that. We can control our own estates. You can control your own estates, but you got to understand where your estate is located at. Your private rights begin where public regulation ends. Private rights begin where public regulation ends. That's the line. Private rights begin where public regulation ends. You can get a job and go to school with a DBA. Most people do not know this. Oh, I didn't know. Maybe you're right. I didn't know that either, if you can. I'm not saying that you can't. You probably can. You probably can. I don't know. Maybe. Is there a difference between public and private and public law and private? Well, public law and private law, that is the difference. Public law and private law. Private law is contract, tort, property, family, private international law. Public law is constitutional law, criminal law, administrative law, tax law, public international law. When I say public and private, that's what I'm talking about. Public law versus private law. Where you're operating, those are the laws that govern the domains. Private law governs the private. Public law governs the public. You only control what you create. Yeah, it seems birthrights come from the Father who is in heaven. Well, yeah, but you do control your own estate, but you got to know where to do that. See, I don't know. When y'all say stuff like that, I don't understand. It's a lot of flowery language. You know, I'm born of the Creator. I have my own estate. We control our own estates. But all that fall under public and private. That means nothing to me until you put it into a because the law, that's what the law recognizes. So the law doesn't recognize this shit you saying. The law only recognizes, okay, are you talking about public or private? That's what when they're going to court, that's what it's recognizing. That's what's in the Constitution, the words public and private. All this other stuff is not in the Constitution. Sovereign is not in the Constitution. Word sovereign is not in the Constitution. The word in the Constitution are public and private. Private rights and public. When you're in the public, you have to create privacy. No, when you're in the public, you need to follow the rules of the public. You create and structure your private affairs. You know, like for instance, it goes back to own nothing, control everything. That's all it is. Own nothing, control everything. Own nothing, control everything. That's it. Own nothing, control everything. That's your mantra. As a matter of fact, that's my 5th law now. My laws are there's a public and private, they don't mix. There is no money. You have to stay in honor at all costs. Do not participate in public controversy and own nothing, control everything. Those are my 5 rules. Although I've read and researched this, I'd like to get your take on legal versus lawful. All that legal versus lawful shit don't mean anything. That's a confusion as well. Put it in Chat GPT. That's all I'm going to tell you. It goes to public and private. He's trying to figure out a way to circumvent public and private. You can't circumvent public and private. You can say that, okay, if you want to say that the statutes are public, which is what they are, and then the common law is private, that's true law or God's law, legal, it still don't matter. It still follows in the public and private. Real law is in the private and the legal is in the public. You can't take the lawful into the legal. They don't mix. So it's still public and private. But you think that you can. That's the issue. Y'all think y'all can mix. You're looking for ways to mix it. You are looking for a way to assert a private right in a public regulatory space, and I'm going to tell you, you're just going to go to jail. That's all that's going to happen. You're going to get locked up. That's all that's going to happen. You have to create privacy within a framework that is protected by the Constitution. You have to create a framework that is protected by the Constitution to operate privately. And that's going to require you to understand those clauses in like freedom of association, due process clause, contract clause. You got to understand how those protect privacy. And when you understand how they protect privacy, then you can begin to structure a system for yourself to operate privately. All right, what time is it, man? How long I been on here? I ain't got no donations. I already know I ain't got no donations. I ain't get no donations. That's okay. I get it next time. 12 presumptions. Let me see. Who is this right here? What is this? Topo? I can't pronounce. Y'all got some names for a nigga. Y'all got some names, boy. What's going on?
How you doing, brother?
I'm doing good.
How you doing?
What's happening?
I had took your SPC University years ago, and then I came in when you was what I remember way in the beginning you was giving out the information for free when people weren't even reading through the YouTube channel. So, and I had got on through your SPC University and became a member when you gave out a deal. Even when your other members weren't studying hard and catching on to everything you said, I was already putting that in the chats about own nothing, control everything. I learned all that from you, and I was on forensics law live not too long ago, and well, a few days ago, and I was mentioning you about how I learned everything in regards how to fill out the DS-11 forms properly.
Right.
That was most important.
Yeah, that passport.
Right.
Yeah.
And everything that you are saying is facts, because understanding it in the beginning and learning and going through this, it's like you're giving yourself a probation period too as well, because you have to, I've learned to really come to understand it more. And in the beginning, you know, your mind be set on, oh, this money, they're wrong, they can't be doing this, fraud. But you have to, I learned that you have to structure your estate properly and have that proper control and come out of jurisdictions in regards to dealing with these laws.
They think they can just declare their way out of a jurisdiction. They think it's just a declaration. Mm-hmm. It's not a declaration. No. It's a declaration followed by a structure that you put in place.
How do you claim rights that you don't even know? You don't know or understand. You know, like how could you say you're owed anything and you don't even have control or understand that once something is dead or once it's a corporation and that everything is business. And like how you were saying about this computer, you got to feed that machine to correct the records and set it straight. But I do appreciate you. I've learned so much in regards to your.
I appreciate it. I appreciate the $4.99. Thank you so much. I appreciate that. See, I'll be happy now. I just got my little donation. I know y'all don't appreciate me like the way y'all used to. Y'all got all these other little fancy gurus and it came up on the scene. That's cool though. You know, the old school, let me just say this, that, you know, we got some information, but I'm probably not going to be in this space too much longer. I am, you know, I'm looking to go on into other things, you know, as far as business-wise, and I'm going to take a group of people with me. And, you know, it's like, because we got to start building some things, you know. All this stuff is cool that y'all are engaging in, but you got to build something. You got a life to live. You got things you got to do. You can't let all of this just consume everything. You're going to waste your life away. You know, if you haven't dedicated yourself to teaching this or doing something like that where you can't get compensated or something like that, then you need to be doing something else with your time as well as studying this. Now, I understand if you got some problem in your life that you need to take care of, yeah, you got to take care of, especially if it's serious. But at the same time, you know, don't lose yourself with this information. It does that with a lot of people. You know, they get you know, it was like that with me. I remember when we first got into this was all we did every day. Like the first 3 years, I mean, you know, I hit the street. This is all we did every day, trying to buy cars, discharge houses, do foreclosures. You know, we trying everything under the sun. You know, numbers on the back of the Social Security card. We're doing all of that, and some things worked and some things didn't. You know, and when something works, that's what keeps you going. But but you'll go through it like about 10 failures, and then you'll get one success, and that keeps you going. And then, and that's the process. That's what happens.
Part of my soul, like you said before, like it's rare that others beat like lower courts. We know they're the lower Roman courts, which is state courts and stuff like that, because how the jurisdictions are set up and things. Like you said, they're doing their job right. Now, I had to come to structure everything like to the T and like really do my research and homework in order to beat them. I just recently beat them in the lower courts before it can even get to the higher courts. And that's why I'm saying I'm very grateful and thankful.
You're welcome.
For the abundance of information.
And that's where that information, that's why I don't come off certain information, because I do know that, like I said, once you've been into the courts, if you've been through this, you're like, I can't believe this shit is real. Some of the things that I read was real.
Right.
That was my first reaction. I was like, damn, they really doing this shit?
Right.
I started noticing things that they doing and how
I went through 8 judges.
Yeah.
3 of them resigned.
That you see all of that, then they'll finally let you go or something like that. And that, but they'll take you through some shit. You'll jump through a whole bunch of hoops
right.
and do some things like that. I call it fatiguing you into compliance. And but there's definitely truth to a lot of it. My thing is though, man, you don't want to go through all of that. Just live your life
at all
where you don't get these entanglements with the public, because man, you can, especially with the feds, the state.
But I'm thankful. I'm thankful because it opened up so many more doors. It opened up so many more doors, though.
It does.
I'm talking about by structuring everything and having the trust and all that set up right. It opened up so many doors and capturing them bonds. When you said about the OIDs and stuff like that, I already knew it.
Yeah. It
right.
Stuff that is real, and it does open up other doors. Just the knowledge in of itself. You're going to. That's what it did for me. Introduced me to all kinds of people, in the financial world and things like that. It will. But once again, I caution.
Buying and trading gold.
Once again, I caution people, though, just watch out for the fanciful. People make fanciful claims and things of that nature. Like when I came in this, people trying to make buying yachts and car, all kind of stuff, and I was like, really? Really? Getting a yacht? I was like, ain't no money. Everything's prepaid. All this kind of stuff. So you'll hear that kind of stuff, but be prepared to, if you're going to do something, to fight for it, because ain't nothing in this space coming easy. Hey, look, man, I got to go, okay?
Right.
All right, I appreciate you. Right?
Thank you for having me.
You're welcome.
Yes, sir.
Hey, look, y'all, I got to get off. I appreciate everybody. Hey, y'all, peace to the gods on TikTok. I appreciate everybody. That was my phone. It's coming through the phone. I appreciate everybody. I can put some beats on this thing. Can I put some beats on this thing too? Can I play a beat while I'm sitting here? Let me see how this. Let me see if this works. Hold on, y'all. All right, y'all. Peace to the gods. You've been listening to the hottest radio network on the planet. My name is Yusuf El. I'll see y'all on my next show. Like, comment, and subscribe. Make sure you like, comment, and subscribe. Make sure you comment under here, and I'll take care of you, all right? And make sure I answer that, all right? Peace to the gods. I'll see y'all on the next live. Peace. I'm out.
Peace out. I'll be ready for the next one. See you then.